Now a discussion on soft money contributions to political campaigns. Today, the Federal Election Commission heard from representatives from the National Republican Senatorial Committee and the American Bar Association, Massachusetts Congressman Marty Meehan, and others. The meeting begins with opening remarks by FEC Acting Chairman Scott Thomas. We're going to bring you the first 4 hours of the event.
Underway. The purpose of today's hearing is to examine issues relating to certain funds received by party committees, commonly known as soft money. The Commission currently is engaged in a rulemaking in this area, and today we'll hear testimony from several witnesses on the issues raised in that rulemaking. The federal statute limits the amount that individuals and political committees can give to federal candidates and to political parties that qualify as political committees under federal law. The statute flatly prohibits corporations, labor organizations, and federal contractors from contributing their general treasury funds in connection with federal elections. Funds that exceed the individual contribution limits or come from prohibited sources are referred to as soft money. Federally permissible funds are referred to as hard money. Since many states allow the use of soft money for state and local election activity, most party committees receive both hard and soft money donations. The Commission's current rules require party committees to allocate the costs of activities that impact both federal and non-federal elections between their hard and soft money accounts to ensure that at least a reasonable portion of the costs of those activities are defrayed with funds that are permissible under the federal statute. In May and June of 1997, the Commission received 2 petitions for rulemaking asserting that the current rules impermissibly allow the use of soft dollars to influence federal elections. The petitions, one from President Clinton and the other from 5 members of Congress, urged the Commission to modify its rules to reduce the role of soft money by requiring federal candidates and the national party committees to raise and spend only hard dollars. The Commission published a notice of availability in June of 1997 and a notice of proposed rulemaking in July of 1998 and received more than 250 comments in response to those 2 notices. Several commenters are here to testify today. I would like to welcome the witnesses who are here to testify and thank them in advance for taking time to share their views. Each witness or panel will be allotted 1 hour to testify. I would ask that the panels limit their opening statements to 5 minutes. The remainder of the time will be devoted to questioning from commissioners and the General Counsel. With that, I would like to introduce our first panel, Craig Engel, General Counsel of the National Republican Senatorial Committee, and Bobby Burchfield and Michael Dawson of the law firm of Covington and Burling on behalf of the NRSC. Good morning, gentlemen. You may proceed as you wish.
Good morning. Thank you. My name is Craig Engel. I am the General Counsel of the National Republican Senatorial Committee, and as Chairman Thomas said, I'm joined here today by Bobby Burchfield and Michael Dawson. Covington and Burling, their law firm, serves as the outside counsel to the Senatorial Committee, and I'm thankful for their support and help in putting this presentation together this morning. And the Senatorial Committee is itself pleased to be here to talk about this important issue for you. After the Commission decided to propose new rules, the Senatorial Committee felt it was incumbent upon a party committee to provide the commissioners with enough legal and documentary evidence to ensure that you can make a thorough and complete decision and evaluate your counsel's draft. We did not want you to rely upon or feel that you had to rely upon any speculation or any assumption. And as you can see, we have provided nearly 1,000 pages of exhibits, including affidavits from key Senatorial Committee personnel. This was an expensive undertaking for us, and we hope our submission in its entirety is well received. In my short opening statement, what I would like to do is just emphasize 4 points that are included in our submission. First, it is the opinion of the Senatorial Committee that this rulemaking is based on an inaccurate premise. That premise is that there is some kind of soft money crisis in campaigns. Common Cause on page 36 of their submission to the Commission, probably stated this inaccuracy best when they said, and I'm quoting from their submission, quote, "It is difficult to define any existing activity of a national party committee, including the promotion of party positions, that does not have as one purpose, or certainly the effect of, influencing a federal election." That's from Common Cause's submission. Commissioners, I'm here to tell you that that premise is absolutely false. The National Republican Senatorial Committee, for example, makes a tremendous amount of non-federal contributions from non-federal sources to state and local candidates. Over the past 2 election cycles, the Senatorial Committee has contributed or expended $8.3 million on behalf of 229 state and local candidates. The National Republican Senatorial Committee is, as its name indicates, a national party committee. Second, the Senatorial Committee believes that this rulemaking focuses on the wrong problem. As I said earlier, there is not a soft money crisis. There is, in fact, a hard money crisis in campaign finance today. This hard money crisis threatens the system that Congress developed and threatens your ability to administer it. As this chart shows, inflation has eroded the absolute value of the 1974 contribution limits to less than a third of its original value. $20,000 in 1974 is now worth just over $6,000 today. I want to state this differently. If the individual contribution limit had been indexed for inflation, it would have gone from $20,000 to over $60,000. That would be what the contribution limit to a national party committee would be today, roughly $66,000. Now, this same erosion of the value of hard dollar contributions has occurred at the same time that the costs of campaigns have dramatically risen. This chart shows network TV ad costs per 1,000 homes. In 1974, it would cost a party committee or any organization $2.27 to reach 1,000 viewing homes. But because of increased costs and, interestingly, viewer fragmentation over cable and new networks, the cost of reaching 1,000 viewer homes today is $11.18, and that is a 5-fold increase. Television time is just one example of the many different campaign costs which have skyrocketed at the time that the contribution limits have remained the same. And I would refer you to the affidavit of Phil Smith in our submissions to talk about the increased costs of even fundraising. Third, and this is important, I believe, for the Commission to know, in inflation-adjusted dollars, the amount of hard dollars that the national party committees have been able to raise since 1984 have barely moved for inflation. If you see in 1984, using total hard money receipts by national committees of the Democratic and Republican parties, keying from 1974 dollars, you will see that total hard dollar receipts have not moved relative to inflation. And that is largely because they are constrained by 24-year-old contribution limits. And finally, if we could put all of these facts together, over the last election cycle, the Senatorial Committee raised $3.1 million in non-federal contributions from individuals. If the individual contribution limit to the senatorial committee had been properly indexed for inflation, in other words, going back to the chart, if the individual contribution limit had been $66,000 rather than $20,000, $2.3 million of the 3.1 that we received would have been hard dollars. In other words, 75% of our personal soft money would be eliminated because of new hard dollar limits. Now, I went through this presentation to suggest to the Commission that you are being led into the wrong solution of the wrong problem. Instead of trying to prohibit money which is outside your jurisdiction, the Senatorial Committee recommends that you work to expand the amount of money within your jurisdiction. And I recommend that the Commission do what it did 10 years ago and author another legislative recommendation to Congress, this time raising or recommending that the contribution limits to party committees be raised and then indexed for inflation. Now, that worked for you in the area of the $1 checkoff. And I believe that the Commission is returning to Congress for continual indexing and raising of that $1 checkoff. That same theory holds true for federal contribution limits. Indexing them for inflation, in our opinion, will allow the party committees to raise more funds within your jurisdiction and at the same time eliminate what many people think is a problem with soft money. There is not a soft money crisis. There is a hard money crisis, and we encourage you to help. Thank you, and now I'd like to ask Michael Dawson to come up for his part of the presentation.
Good morning. My name is Michael Dawson of Covington and Burling.
Michael, excuse me. We were hoping to try to keep the opening remarks as close as possible to 5 minutes. I don't mean to rush you necessarily, but if possible, if we could get the highlights so that we could move into the questioning phase, that would be helpful to us.
Very well. I think we understood the 5-minute period to apply per speaker as opposed to per panel. I will limit my presentation to just 2 quick points. The first is that for 2 decades, this Commission has correctly taken the position that it does not have the authority to ban soft money. Your own regulations permit national party committees to raise and spend unlimited amounts of soft money. And just last March, this Commission unanimously affirmed the right of national party committees to transfer soft money to state party committees, complete with instructions on how to spend that money. Similarly, the Supreme Court in Colorado Republicans has adopted the view that you lack the authority to ban soft money. Here's a quote from page 616 of that opinion where they say, "We also recognize that FECA," and we think this is very important. It says FECA, not the Federal Election Commission, but FECA permits unregulated soft money contributions to a party for certain activities, such as electing candidates for state office and for voter registration and get-out-the-vote drives. Given the Commission's long history of interpreting its statute to limit its jurisdiction to hard money only and not to soft money, we submit that you may not depart from that interpretation absent compelling evidence, and there is no such compelling evidence in this record. I want to just focus on one piece of evidence in the record that we think is especially important. Those are the evidence documented by the Annenberg studies attached to our response. Those studies show that in the past few cycles, we have seen an unprecedented increase in political spending by individuals, corporations, labor unions, nonprofit membership associations. In fact, the Annenberg study estimates that in 1996, those entities spent roughly $75 million on issue advertisements. We think it's very important that the Commission understand that if you adopt the proposals before you today, those entities will still be free to speak. 2 decades of judicial precedent says that you may not limit or even require disclosure of money spent by labor unions and corporations to, say, pay for issue ads. If you prohibit labor unions and corporations from giving money to national party committees, they will use that money to engage in speech like issue advocacy directly or through 501c4 corporations. And the effect, perhaps the unintended effect, but the effect of your proposed rules would be to drive political money from the national party committees where it is disclosed to labor union and corporation direct issue speech where that activity is not disclosed. With respect, we submit that a step that would decrease the amount of information disclosed to the public is not the right step. Thank you.
Thank you. Mr. Burchfield.
Morning. As always, it's a pleasure to appear before the Commission. I am Bobby Burchfield from Covington and Burling. I will address briefly the grave constitutional issues that we believe are raised by the proposed rules. First, by imposing federal contribution limits on political parties whenever they participate in state and local races, the proposal would override the legislative judgments made by 50 separate state legislatures. As Mr. Engel has demonstrated, the national political parties are actively and continuously engaged in activities on behalf of state and local candidates. For this Commission to tell the national political parties that they can participate in state and local races only if they comply with federal contribution limits would impose federal views on these sovereign decisions by the states. Such a rule would, we believe, be bad policy, go well beyond what Congress authorized in passing the Federal Election Campaign Act, and violate both the 10th Amendment and constitutional principles of federalism. We note that none of the proposals under consideration, other than no change in the regulations, would allow House and Senate committees to make contributions to state and local officials of non-federal funds. Second, by forcing political parties to reduce their political activity by hundreds of millions of dollars every election cycle, the proposed regulation raises serious and we think fatal First Amendment concerns. As the Supreme Court has made clear in Buckley, political spending is core speech protected by the First Amendment. Such speech can be restricted only if there is a compelling justification. The Supreme Court has held that the only compelling justification is to eliminate corruption or the appearance of corruption, which it defines very precisely as, quote, a financial quid pro quo, dollars for political favors, unquote. This record contains no evidence that soft money corrupts federal officials. Make several points on that. The constituencies who today advocate eliminating soft money have argued for many years that there is too much money in politics. In Buckley, however, the Supreme Court specifically said that that is not a constitutionally sufficient justification for restricting campaign finance. Additionally, when Congress passed the Federal Election Campaign Act, each member knew very well that political parties and candidates raise money by the participation of office holders and candidates. They also knew that they would continue to be instrumental in raising money, hard money or for federal races or money for state and local races. Even so, Congress set a contribution limit for political parties at $20,000, $66,000 in today's dollars, confident that legislators would not trade legislative favors for that amount of dollars, even in face-to-face fundraising. Candidates continue to raise hard dollars for their parties and their own campaigns. The suggestion that soft money buys so-called access and thus should be banned is a simple non sequitur. That proposition would lead to banning all political fundraising for hard and soft money that involves direct contact between contributors and candidates. Congress clearly did not intend that result. Additionally, because no single soft money donation constitutes even half of 1% of a party's funding during an election cycle, the suggestion that a soft money donation to a political party has the propensity to change the party's position is, we would submit, absurd. The suggestion that the public has lost confidence in government because of soft money is also complete speculation. There are many reasons for the public to gain or lose confidence in government: the character of office holders, the government's action or inaction on particular issues, and even the rise and fall of the stock market. Yet when asked in public opinion polls which issues are important to them, respondents to public opinion polls never list campaign finance as a burning issue. For example, in the June 1998 NBC News Wall Street Journal National Survey, respondents were asked, quote, "Please tell me which one or two of the following issues will be most important to you in deciding how to vote in this year's elections for U.S. Senator and Congress." 43% listed preserving Social Security and Medicare. 40% listed improving public education, and so on down the list. And you come to campaign finance, which only 8% listed. There is, in short, no public outcry for banning soft money. Third and finally, the staff interprets the Supreme Court's opinion in Buckley as giving the Commission authority to regulate essentially anything political parties do. Of course, the passage they cite appears in Part 2 of the opinion, which deals with reporting and disclosure requirements. Here's the Buckley case. Starting at page 60, the Court discusses reporting and disclosure requirements. That is the only issue under consideration in that section of the opinion. The Court notes, of course, the obvious point. We note and agree with appellant's concession that disclosure requirements, certainly in most applications, appear to be the least restrictive means of curbing the evils of campaign ignorance and corruption that Congress found to exist. This is disclosure. It is the least restrictive regulatory mechanism. The Court goes on to specify the issue it's addressing in the passage that the staff relies upon. It says, Section 434E applies to, quote, every person who makes contributions or expenditures, unquote. Quote, contributions and expenditures are defined in parallel provisions in terms of the use of money or other valuable assets for the purpose of influencing the nomination or election of candidates for federal office. It is the ambiguity of this phrase that poses constitutional problems. Then we get to the phrase that the staff focuses on, still in Part 2, dealing with disclosure. Although the phrase "for the purpose of influencing an election or nomination" differs from the language used in Section 608E1, which is the independent expenditure provision of this prior version of the Act, it shares the same potential for encompassing both issue discussion and advocacy of a political result. The general requirement that political committees and candidates disclose their expenditures could raise similar vagueness problems, for political committee is defined only in terms of amount of annual contributions and expenditures, and could be interpreted to reach groups engaged purely in issue discussion. The lower courts have construed the words political committee more narrowly. To fulfill the purposes of the Act, they need only encompass organizations that are under the control of a candidate or the major purpose of which is the nomination or election of a candidate. Expenditures of candidates and of political committees so construed can be assumed to fall within the core areas sought to be addressed by Congress. They are, by definition, campaign-related. I respectfully submit that in the context in which this quotation appears in the Buckley decision, given the reference even within this paragraph to the issue of disclosure, it is not fair to read this passage the way the staff suggests as giving the Commission a carte blanche to regulate in any way it chooses anything political parties do. For these reasons, the factual reasons Mr. Engel has raised, the statutory and historical reasons that Mr. Dawson has raised, and the constitutional issues that I have just discussed, the National Republican Senatorial Committee respectfully submits that no rulemaking here is appropriate. We stand ready and look forward to your questions. Thank you.
Thank you, gentlemen. Just to alert my colleagues, what I intend to do in terms of questioning is basically do a rotation so that some colleagues will start with the first panel, but then I'll rotate to someone else to start with the next panel, and so on. That way we'll sort of have equal distribution of who gets to start questioning with respect to particular panels. I will take the liberty of starting with this panel, I guess, myself. I just wanted to, first of all, get clarification. The NRSC is classified for tax purposes as a 527 organization. Is that correct?
That's correct.
Okay. And I'm just asking that question because under the tax rules, to have that kind of treatment, you basically have to live with the statute for tax purposes that defines a political organization under 527 as one that is a party, committee, association, fund, or other organization, whether or not incorporated, organized and operated primarily for the purpose of directly or indirectly accepting contributions or making expenditures, or both, for an exempt function. And then it goes on to define exempt function as the function of influencing or attempting to influence the selection, nomination, election, or appointment of any individual to any federal, state, or local public office or office in a political organization, and so on. I only wanted to nail that down because I think one issue that you raise in your comments is that the party committees have many other kinds of purposes. And I just wanted to clarify that for tax purposes, you're living under a statutory provision that suggests that your primary purpose is the nomination or selection of candidates. Is there any fact that I should be aware of that would suggest that that tax concept is not in fact applicable to your organization? Is your primary purpose something other than the selection of candidates?
Well, Commissioner Thomas, I would refer you to the affidavit of John Highbush, which is included in our submission, to probably give you the best overall understanding about what the National Republican Senatorial Committee does. That would show what its various purposes are. Its primary purpose, of course, of its federal account is the election of federal office holders.
Okay.
Commissioner Thomas,
Mr. Burchfield.
Acting Chairman Thomas, there is a gap, I think a well-recognized gap, between what the Internal Revenue Service can denominate political activity, which is very broad and which is encompassed within its tax exemptions, and what is disqualifying for purposes of other tax status, such as 501c3 status or even a 501c4 status, versus what this commission can regulate under the First Amendment. The law, I believe, indicates that a tax exemption, as a matter of legislative grace, can impose certain restrictions on activity that the First Amendment will not allow this commission to impose on a political committee within its jurisdiction. Just because an entity is a 527 corporation doesn't mean it's within the jurisdiction of this commission. Just because it is a 527 corporation doesn't mean the only thing it does is make contributions to and expenditures as defined in the Federal Election Campaign Act in federal elections. So, and that is my reading of the law and the case law surrounding it.
Just to follow that up, does the NRSC have any organizations under its control that it has set up as C3 or C4 or any other type of 501c type organization?
No.
No? The only other question I would like to get into briefly is just with regard to the process of raising money. That's really the heart of this hearing. Is there not, in fact, a series of practices or a pattern, if you will, that the NRSC has established whereby folks who give the largest donations are encouraged to do so by offering them special perks, if you will, special opportunities to attend certain fundraising events, certain opportunities to appear at events where leaders of the party and high-level officials in the legislative sphere are in attendance?
Well, I would start off by disagreeing with your characterization about what this rulemaking. It's not about raising money. It's about prohibiting us from raising money. But I would say in answer to your question that in any organization, ours, of course, is not a government organization. We are a political party committee. We are similar to charitable organizations and issue groups, that there are different donor programs at different levels. And different levels of different donor programs often involve different meetings and different events and different social gatherings.
Maybe I should have asked it in context of what do the Democrats do? Maybe you would find it more easy. You'd find it easier to talk about what the Democrats do in terms of motivating donors.
I don't know.
Mr. Thomas, I think,
Burchfield.
Commissioner Thomas, I think Mr. Engel may be able to give you some more details on this. But as I understand your question, the question is whether, ultimately, whether donors of soft money to political parties achieve some sort of are induced to give those donations by the promise of being able to meet with, in a seminar context or social context or whatever, candidates and office holders that participate in the National Republican Senatorial Committee. If that is the question, the answer to the question is yes. Donors of soft money, just as contributors of hard money, are allowed access on a regular basis to senators and office holders at social functions and seminars put on by the NRSC. Indeed, my understanding, and again, Mr. Engel can elaborate on this, donors of hard money, $5,000, $1,000, $20,000, receive invitations to seminars where they get to meet with United States senators. Donors of soft money get similar, although my understanding is lesser, opportunities to do so than donors of hard money. As I indicated in my comments, that indictment of soft money is an indictment of all private contribution activity in this country, whether it is charitable contribution activity or whether it is political contribution activity. And I believe Mr. Engel can provide you the details on what on the fundraising programs that the NRSC currently runs for hard and soft dollars.
Sure, we have a lot of different donor programs at the Senatorial Committee based on the level of a contribution for $1,000, $5,000, $10,000, $20,000, and then we have other soft money donor programs as well. Each one of those has a name or a unique identifier, and each one of those involves maybe the attendance at fundraising events, parties, social gatherings, where there's mix and mingle, senators, candidates, other luminaries, former government officials come, and the standard routine would be for them to give a speech, take questions from the floor, and it's primarily, I've been to many of these things, a social gathering among our donors, like-minded individuals who have become friends over time, are able to mix and mingle with each other and give or listen to speeches of senators, congressmen, public figures, and there's question and answer periods as well. These happen both in Washington, D.C. and around the country, including at the party convention as well.
But is it fair to say that the bigger donors get more of those opportunities than the smaller donors?
No, it is not.
And okay, your testimony is that that is not the case. All right, fine.
Well, my testimony is that it's not the case because a certain one of our donor programs at a medium level have more meetings every year.
Okay. Mr. Mason?
Thanks. Mr. Burchfield, going back to your citation of that provision in Buckley related to the campaign-related activity of political committees, thank you. And I
Yes.
take your point that that's related to disclosure. But even restricting it to disclosure, it's a fairly broad statement, perhaps unintentionally broad, I don't know. But let's take the difficult case of political party advertising, which falls short, perhaps far short of express advocacy, but which mentions a particular candidate. What campaign would that advertising be related to? Given the Supreme Court statement that all political party spending is by definition campaign related.
For purposes of that passage, that spending is reportable under current Commission regulations. We believe the current Commission regulations go as far as that passage allows the Commission to go. To respond more directly to your question, as you know, I represent another client in connection with a challenge to whether the Commission can do any more than require disclosure of such non-express advocacy by political parties. The courts have held repeatedly over the last 20 years that labor unions, corporations, trade associations, other political committees, besides parties, individuals, cannot be regulated by engaging in non-express advocacy. Our position in that case is, and I believe the Senatorial Committee would agree with the position we're taking in that commission, but in that case, but Mr. Engel could speak to that. Our position in that case is that political parties have the same right to engage in issue advocacy as those other entities. Now, as to what candidate is being addressed in such an ad, my understanding of Commission precedent is the same rules apply to those advertisements whether a candidate is mentioned or not. If the advertisement says support the balanced budget amendment and does not name a candidate, the same 65-35% allocation rules, 65% hard dollars, 35% soft dollar rules apply to that advertisements as if it says support the balanced budget amendment and you call Senator Doe and tell him to support the balanced budget amendment. The same allocation rules apply. So the commission has never recognized, does not currently recognize the distinction between the naming of a candidate and the not naming of a candidate in that situation. How the Supreme Court would answer the question of which campaign that's supposed to relate to, I don't know. That's why I think it's perilous to read this passage more broadly than just dealing with the disclosure of receiving and disbursement of money by political parties.
Related to a question which I know is going to come up later and none of you addressed directly, and Craig or Bobby or both may want to address this, but the Senatorial Committee recently submitted an advisory opinion request regarding the party allocation rules. And essentially the Commission's, I think, undisputed ability to establish allocation rules is the principal existing citation to our regulatory authority to, in essence, expand those rules, if you will, to 100% allocation ratio, and to perhaps to expand them to activities that aren't even currently allocated. And my question is, if those rules are cited as a statutory authority, wouldn't it follow that we could also establish a zero allocation percentage or some other percentage as requested in, for instance, the advisory opinion request?
The Senatorial Committee's advisory opinion request last month was meant to indicate to the Commission that there was a technical defect in what I believe to be your interpretation of the rule, that the funds expended method of allocating a disbursement cost at a Senatorial Committee must actually be an accurate allocation method and should not be restricted to a 65-35 arbitrary minimum or cap. And I feel as though, and I feel today, that that is a technical problem with your rules, which treats a party committee quite differently than any other political committee which is operating under a funds expended basis. These proposed rules would exacerbate that problem by treating party committees quite differently than other organizations. Other organizations would continue to have 100% soft money activity, and the Senatorial Committee would have none.
Let me follow up on that as well. First of all, Commissioner Mason, a 0% allocation percentage, as in other words, changing the ratios in Section 106.5 from 60-40 in some instances, 65-35 in others, to 100% zero, is not this proposal, because the allocation that is addressed in that regulation encompasses some, but not all, activities of a political party. The current rule would apply a 100% hard money requirement on political parties for all their activities. It would.
Yeah, that was my assumption, that the effect was both to raise the ratio and to expand the category of activities which the ratio was applied to.
Correct. And perhaps one of the more offensive aspects of the provision from our perspective is the fact that it precludes the NRSC, the Republican National Committee, the Democratic National Committee from supporting state and local candidates. And that is something that Congress didn't authorize in the Federal Election Campaign Act. It's something that we believe the courts would not sustain under the 10th Amendment jurisprudence and under the federalism jurisprudence. But even apart from those issues, changing the allocation percentage for those limited areas that are encompassed within Section 106.5 of the regulations currently would need to be reasonable. It would need to pass a judicial scrutiny of reasonableness. And as you know, the Commission has recently argued before the district court here that the 65-35 percentage is reasonable and is a careful balance between the need for parties to pursue federal-related activities and non-federal related activities. To lower it to zero, I think there would be a serious, certainly non-frivolous challenge to such an action on the grounds that that does not reasonably take account of what the political parties actually do.
I won't pursue it much longer, but I just want to get back to this question, though, about the statutory basis, and that is, if this is part of the statutory basis, wouldn't it also apply that the allocation ratios could be adjusted downward as well as upward, and that the category of covered activities could be restricted as well as expanded?
Within a range of reasonableness, I believe that's correct. I would note that the only court that has addressed that is the district court here in D.C. in a challenge between Common Cause, which advocated such an allocation. There were no political parties who would be directly affected by that allocation participating in that case. I don't know if the result would differ if the political parties, on the basis of the current record here, were to come in and challenge that. But I take your point that it is at least hypothetically possible within a range of reasonableness to change that percentage. Now, 65%, 35% might be the most aggressive, sustainable percentage. It would depend upon the factual record.
Commissioner Sandstrom?
First, I'd like to apologize to the panel for my tardiness. And I think there may be a number of things we may be in agreement on, including maybe whether the proposed regulation is under-inclusive. But in the short time permitted here, I wanted to maybe explore some of those areas where we may not be in complete agreement. And first, I want to take a little instruction from Stephen Jay Gould, who points out that the year 2000 is actually the last year of the 20th century. So I note that first, that the election in the year 2000 will be the last election in this century, and I'll hearken back to the first election in this century, 1904, and I would ask the panel if any of them will recall who were the biggest soft money contributors in the 1904 presidential election. See, I may have stumped the stars here.
It was before my time, I'm happy to say.
That's a personal anecdote, Commissioner.
I'm like youthful Norwegians. You know.
Yeah.
Though you have a few years on me. I believe they were J.P. Morgan, Standard Oil, and the Goulds. And I would note that it seems to be something about monopolists who do find ideology here. I noticed Microsoft has found the avenues to make soft money contributions, taking lessons from the predecessors. I would ask then, who were the biggest soft money contributors in the 1996 96 and 98 cycles.
Commissioner, I wouldn't know them by name.
Would you be surprised if the cigarette cartel now might join Standard Oil and J.P. Morgan as large soft money contributors?
I would be surprised if cigarette manufacturers were large or the major soft money contributors in the 98 cycle.
If
With all their problems, Commissioner, I think antitrust issues are not one of the ones that the cigarette companies are currently experiencing.
I think, when I refer to them as a cartel, maybe just a cartel of knowledge, and that they all seem to have the same understanding of nicotine and its addictive qualities. And so maybe I'm not talking in the economic cartel, just an intellectual cartel. As I had in the 96 cycle, Philip Morris was the largest contributor of over $3 million in soft money. Would you have any reason to dispute that?
You're referring now to the 96 cycle?
Yeah, the 96 cycle.
Okay. What date are you using?
The 95, 96 cycle.
To whom?
To everyone. Just the largest soft money contributors. I have, this list I have here, lists Philip Morris as number 1, Joseph Seagram's as number 2, and Nabisco, RJR Nabisco is number 3. Do you have any reason to believe that to be inaccurate?
I have no reason to think that is inaccurate. Is that meant to be to all party committees, not just the senatorial committee?
Yes.
Okay. I have no reason to think that's inaccurate.
With respect to, during this period of time, over the last 4 years, have the cigarette manufacturers had any particular legislative interests?
Have the cigarette manufacturers had legislative interest? Yes.
Okay. With respect to the appearance of corruption, using a criminal analogy, do we really care where an extortionist deposits the money? Or, if he deposits it in his personal bank account or he deposits it in a charity? With respect to, the purpose of, a person we're accused of extortion, we don't really care where they deposit the money.
I would answer that by saying that there is absolutely nothing that you could do today or that are in these proposed rules that would prevent that from happening. Whether it's a soft money contribution, a hard money contribution, a contribution to a charitable source, or a contribution to an office holder, there are bribery statutes which cover what you're intimating.
I didn't know I was intimating anything. I'm just wondering, what relevance is it for the appearance of corruption? I understand you may find that justification rather weak, but if you're using that justification, does the appearance really change depending on what bank account you deposit it into?
I really don't know how to answer your question.
Okay, I will yield and hope we come back around.
I hope we can. Commissioner Elliott?
Thank you. I'm particularly glad that you came to testify, since you're the only party committee, and these seem to be aimed at party committees. And so I'd like to use you as the focus of some questions and concerns that I have that distinguish party committees from others that are doing the same thing. Now, it seems like the proposed rules, or some of them, would say that party committees cannot spend soft dollars, or at least have to allocate soft dollars, for registration and get out the vote activities. Whereas the League of Women Voters and all types of ethnic groups can take huge amounts of the money from corporations and unions and use them for the very same activities without any allocation. In fact, most of them don't even have 2 accounts to allocate between. So it seems there is an equity problem here. Now that goes to the registration and vote. We get into a much bigger problem, it seems to me, when we get into issues. Issues that the party expresses itself on supposedly have some interest to its members and the candidates it represents. But And they must be allocated too if there is any, well, that would have to be paid out of hard dollars if they were express advocacy. And then there is the question that we're grappling with about those that are not express advocacy and how close can you come. Yet at the same time, think tanks all over this nation can take all kinds of corporate and union funds to express themselves on issues all over the place, as do the League of Women Voters and the ethnic groups that are urging people to get out. How can you restrict one without restricting speech by all these groups? That's my question. Bobby?
Commissioner Elliott, you're exactly right. You put your finger on what, from a policy perspective, is the biggest problem with this rule. To go back to Commissioner Sandstrom's point a minute ago, the allegation of improper tobacco company influence was not through their direct, in this last election cycle, as I read the papers, was not through their direct soft money contributions. It was through their independently run issue advertisements. That is exactly what will happen. I don't think we should kid ourselves. That is exactly what will happen if the political parties are precluded from taking corporate and personal soft money. Those same companies, those same individuals will merely increase what they're already doing. The League of Women Voters obviously already is engaged in voter registration activities, and there's no way that we will know where their money comes from. It could come from the tobacco companies. The AFL-CIO is engaged in those activities. To the degree that those sorts of activities influence federal elections, that is an entire range of activity that the courts have ruled is outside, for First Amendment purposes, outside this Commission's jurisdiction. And to take an action in this rulemaking which has the predictable consequence of pushing money outside at least the disclosure process into an undisclosed situation strikes me as it is neither accomplishing the policy that the Commission is pursuing, nor is particularly good public policy.
Thank you. Thank you, Mr. Chairman.
Commissioner Wald.
Gentlemen, thank you for being here. You and a number of the other commentators who are either going to testify in person or submitted written comments have provided very useful information for the Commission, and we thank you for the efforts that you have put into this to assist us in our efforts. I just have a quick question, a couple quick questions about some of the statistical information that Mr. Engel provided, because that may have implications for some of the other presenters today also. And I want to make sure I understand the implications of those statistics. Did I understand you to say that the NRSC, at any rate, has, in terms of constant dollars, 1974 dollars, has been able to about hold its own in the absolute amount of hard money contributions that have been received in the years since 1974? Is that basically right?
It's my understanding that the Senatorial Committee, along with its other national party committees, have been able to, since 1984, just about keep pace with inflation.
All right. So you're bringing, in terms of constant dollars, you're bringing in about the same amount in hard money that the current election cycle that you did back in 1984.
Correct.
Okay. But the statistic that seemed to be missing there from the presentation was the increase in the number of voters since 1984. If the population to which those hard dollars are used to communicate has been going up substantially, which I think we're all aware has been happening, the actual dollars per voter that have been used for communication has actually gone down then. Would that be a fair conclusion?
That would be a fair conclusion.
And in addition, the costs of communicating with those voters have gone up much faster.
Well, let me ask you
CPI.
about that. I remember that statistic or that chart, but I wonder if that isn't just the flip side of the diminishing value of the 1974 dollar, though, because that, or have those costs gone up faster than inflation? Is it now, in constant dollars, is it more expensive to communicate now than it was in 10 years ago or 20 years ago?
the relative comparison, as I understand it, Commissioner Wald, is that the CPI, the Consumer Price Index, which was the basis for adjusting the $20,000 down to $6,600, has gone up about a little over 3 times. The cost of media advertising has gone up, once you make all the appropriate adjustments, has gone up over 5 times.
I see. Okay.
And that is the result of that does not take account of the increased number of voters that you've pointed out. It does control for the number of people watching those shows. It takes into account the fragmentation of viewership over cable networks and so forth, which really wasn't a factor in 1984.
And I would layer on top of that, and this is data that is in Phil Smith's affidavit, the increased costs in raising the money as well.
All right. One other question on that line then is that basic level effective or level amount in constant dollars of the hard money contributions due to any change in the efforts that either the NRSC or other party committees that, to your knowledge, have put into raising hard dollars versus soft dollars? That is, have you said hard dollars are too hard to raise, we don't need them, we're going to focus entirely on soft dollars, or has it been the other way around? We're putting a maximum effort into the hard dollars, and this is the best we can do. What's the analysis of that?
The Senatorial Committee puts the maximum effort it can into raising as much hard dollars as it can. Any sort of decline that you've seen in our overall receipts in hard dollars relative to inflation is not attributable to a lack of effort. It is attributable to the fact that contribution limits have remained static and that the amount of money it takes to raise hard dollars is increasing as well.
And lastly, I take it the amount of hard dollars and the amount of soft dollars all determines the amount of communication that can be ended up in the end delivered to the voters.
Absolutely.
Dollars means communication.
Yes, sir.
Thank you.
Commissioner McDonald?
Mr. Chairman, thank you. Bobby and Craig and Michael, thank you for coming. It's always good to see a former member of the General Counsel's office and an executive assistant get to such exalted heights. And Bobby, I trust you didn't charge Craig by the word.
We write fast.
This is a fairly impressive document, I must say. But welcome. It's important you're here, and it's an important matter. And I hope I detected in a few responses that there's kind of an underlying theory about whether or not something is good or bad, and that really won't be the nature of my questions, because I think what we're really trying to do is just have some sense of the debate. And I'd kind of like to start with your document, because I noted that on page 3 of the summary of comments, that 1994, the average contribution to the NRSC was $39, and in 1996, it was $50. I don't think anybody would deny that an average, or if you took a mean or anything else, that would be a problem. And there may not be any problems at all, as you suggest, but I just wanted to kind of clarify a few things with you. I'm looking at the receipts for your committees from 1995-96, in which 601 transactions raised $79,916,562. And I don't think the concern is $39 or $50. I think the concern, right or wrong, we'll get to that later, but I think the concern is more along those lines. And I did think that it was important that we try to frame it in the context of what at least some of the concerns are. I would gather that from Buckley you would surmise that money and speech are kind of interchangeable. Would that be a fair assessment? That that's the reason that it does help to be able to communicate the issue of free speech in Buckley?
The court in Buckley, we believe, drew that equation. Not all money necessarily would be used for speech, but in the political context, the court recognized, I think it's pretty widely accepted, that to speak in the political context requires an increasingly large amount of money.
Well, on that point, first of all, I agree with the presentation that Craig made, because he is right. I think that we had talked about for some time and had made recommendations, and as he knows, we've had unbelievable success. I'm hoping the Republican Congress will no doubt embrace a number of our proposals, which we've sent up, because over the years we haven't had much luck, but I'm hopeful that now things will change. But the only problem, of course, on the other side of that equation is without money, it turns out you don't have any speech, which is yet another problem. Free speech, it turns out, isn't very free, as I gather what you're telling me. Actually, it's fairly expensive, is what you're telling me. Is that not right?
That's correct.
Okay. I just think it's important. It's a term that gets used quite frequently around the Commission about free speech, and I'm always interested in that because, of course, as a concept, it's not only not free, it's exceedingly costly, as I think your presentation would demonstrate. Let me just ask a question about, I'm trying to think how we should frame this. If you take the position that the underlying theory behind the act would be what? For any of you who would want to answer that question. What is the underlying theory under the Federal Election Campaign Act?
Well, Commissioner, in my opinion, the underlying theory behind the Federal Election Campaign Act is that there is a narrow group of contributions and expenditures which you can regulate. That is done with great caution because of the First Amendment concerns, not of the things that you cannot regulate, but even of those things that you can. And that for $1,000 contributions to candidates or $10,000 or $20,000 contributions to party committees, that is within your jurisdiction. The underlying problem, though, has been that those numbers have not been indexed for inflation. Because of that, it has created symptoms in other areas which many people who are not party committees are pointing to and urging you to address that. The Supreme Court, though, in my opinion, has told you what your jurisdiction is. And my recommendation is that you should work to expand the money within your jurisdiction, not work to prohibit money that is outside your jurisdiction.
Well, let me ask about that, Craig. I think it's a good point. I think you, as always, you always make a good presentation. Let me just ask you about that. Are you suggesting then that if the money had been indexed and we had $66,000 as opposed to $20,000 used in the example, are you suggesting that that being the case, and if in fact there was a way to get at issue advocacy groups so that that money wouldn't keep flowing away from the parties but would flow back to the parties, then this problem of soft money would go away? Or is it just another avenue on top of soft money? I'm just trying to understand. You made the presentation in relationship to soft money, and you used the example you would have had a lot more hard dollars under an indexing scheme. Right. Are you taking the position that if they were indexed by the Congress of the United States, then you would no longer be interested in soft money?
My position is if the hard dollar limits had been indexed for inflation, right, we would be able to raise more hard dollars, including money which is being deposited in our soft money accounts. Many times people will come to the Senatorial Committee and say, how can I do more? I want to effectively communicate my support of the Republican Party. And we have to tell them, because of a $20,000 or a $25,000 limit, that your speech must be directed in a different avenue. I think the solution for those people who wish to be able to effectively communicate their message should not be prohibiting them from giving party committees soft money. It should not be to direct them to other groups which do not disclose at all. But instead it should be to direct them toward a system which we would encourage, and I think you all would encourage as well, is hard dollar contributions for hard dollar advocacy that is completely disclosed by the Senatorial Committee.
Commissioner,
sure,
if I could chime in on that point and the related one from your earlier question, I think it is important to distinguish the motivations of Congress in passing the Federal Election Campaign Act from what the courts have deemed to be permissible in regulating political speech. As we know, the motivations for passing the Federal Election Campaign Act initially were to reduce the amount of money in politics, was to level the playing field among candidates, and really subsidiarily to eliminate eliminate corruption or the appearance of corruption. The Supreme Court held that those first two reasons are not sufficient to regulate speech, to regulate political speech, and accordingly it has focused on limiting corruption or the appearance of corruption as the only justification for regulation in this area. And as a result of that, many parts of the Federal Election Campaign Act, as was originally passed, did not stand up under constitutional scrutiny. So I think we should not so much focus on what the intention of Congress was in passing the act as on what courts have subsequently said are the appropriate intentions.
Well, it's an important exchange to have, and I appreciate it, because when Craig was responding, I was thinking I actually got an entirely different point of view. This wouldn't come as a shock to Craig, but it would concur with you. I think the underlying theory was that the public, one, had a right to know, that two, historically speaking, going back to the Tillman Act and really even before the turn of the century, the theory was that large concentrations of money might create a problem. And the courts have really not struck that down. I mean, one of the things I'm always fascinated by in these exchanges is what the courts did do. Now, they initially, when they struck down some provisions of Buckley, for example, the amount of TV time you could have or couldn't have and things like that, which is going back a ways, that was a different issue. And they didn't think that you could corrupt yourself. They thought someone else might be able to corrupt you. And that's the reason I was trying to get kind of what the theory is behind the law. As my friend who I see out in the audience, Cleta Etheridge, will tell you, I'm very partial to state and local government, so I'm interested in state and local candidates. When I was in county government, I used to attack the state. When I was in state government, I used to attack the federal government. You can now see my problem. But that's a thought. But it's everybody's already on it. But I'd close just by saying that, one, I wish we had a lot more time because I think you all bring some very interesting and important discussions to this. I hope we can visit more about it. I just say in summary, though, because I think it is kind of important, I don't think the issue, and there's quite a bit of material, well thought out material in here in relationship to what we could and could not do with state candidates and local candidates. I don't think that's really our concern, and I don't even really think that's what this debate is about, because the issue, of course, is in relationship to a federal election, and I don't know, maybe some of my colleagues take a different posture, but I don't take the posture that we could get into that. The more realistic question that everybody has to try to grapple with around here is whether or not, in fact, a substantial amount of soft money doesn't, in fact, affect the federal election. That's the issue before us. Thank you very much, and thanks again for coming. I appreciate it very much.
Thank you.
Mr. General Counsel, Larry Noble, do you have any questions?
Yes, thank you, Mr. Chairman. I want to start with a follow-up to Commissioner McDonald's question, which I'm sorry, I must have missed the answer to. If the hard money limits were indexed for inflation, would the NRSC stop raising soft money?
No, because the Senatorial Committee could not raise corporate contributions into its hard dollar account.
So you would still see a need to raise those corporate contributions regardless of indexing the limits for inflation?
Yes.
Okay. You stated in your oral testimony that the NRSC spent $8.3 million on behalf of state and local candidates. And in the written portion of the testimony, you say that it was spent on contributions and expenditures on behalf of state and local candidates. Do you have a breakdown of how much of that was actually contributions?
Not with me, but I could provide that to you. It breaks down into contributions or independent expenditures.
If you could provide that breakdown. Now, talking about the independent expenditures, are you defining that as an expenditure that expressly advocates the election or defeat of a state or local candidate?
Yes.
So you're not counting so-called issue ads in that?
Not at all.
Okay.
And that's per the advice of the Commission. in an advisory opinion, it pretty much, and in the regulations and the explanation of justification, your advice was contributions or expenditures are what you tally toward your federal or non-federal candidate support.
Now, following up on something that the chairman asked about, we talked earlier about the NRSC having different programs for different levels of donors. And you ended by saying that, in fact, the mid-level donor may get invited to more functions than the high-level donor.
Correct.
Are the nature of the functions the same?
Generally, yes.
Could I interrupt just 1 minute on that point? Do you realize that this may be on television and how many high donors you're going to lose when they find out they can get in a hell of a lot cheaper than they currently are?
Well, you're talking about the other party, weren't you?
I'll give you an opportunity to rethink that, Craig.
Well, let's examine it a little bit for the benefit of your high donors. Has the NRSC ever put out a solicitation that distinguishes the access that will be given to office holders based on the level of donation? For example, $50 donation, you may be invited to a fundraiser where people mingle. $100,000 donation to the soft money account, you may be sitting at a breakfast table with 2 or 3 of the office holders of your choice. Have you ever seen the NRSC put out such an invitation?
Not like the one you have described, no, but I would say that there are different levels of giving, and different levels of giving may allow you to be invited to different events.
And let me also follow up on that, Larry, because the point that we're trying to make with regard to that is that it isn't that the quote unquote access you're talking about isn't unique to soft money. It is also the case that hard money donors of $5,000, $1,000, $20,000, perfectly legal hard dollar contributors are invited to NRSC events, and they hear speeches by senators, they participate in roundtables with senators, they shake hands with them, they sometimes even have a beer with them. That is not something that's unique to soft money contributions. And to assume, I think to assume that Congress, when it passed the Federal Election Campaign Act, intended to eliminate all fundraising, personal fundraising participation by sitting senators or congressmen, I would respectfully submit that that's not accurate.
So it is your testimony then that the $100,000 donor, the $250,000 donor gets no greater access than the $20,000 donor? No greater, has no greater contact with individual candidates, has no greater choice of contact with the people, has no greater opportunity to meet on a more of a one-to-one basis or a 2 to 3 to 1 basis than the $20,000 donor?
Let me respond to that in a couple of ways. Number one, as the fundraising programs of the NRSC are structured, the answer to that is that's correct, that $100,000 donors do not get more meetings with candidates and senators than $5,000, $20,000 donors.
But are they in smaller groups when they meet with those donors?
I think there are probably fewer of the $100,000 donors, but the nature of the meetings is the same. The second way I would respond is that large corporations who, as Commissioner Sundstrom was saying, have extensive lobbying operations in this town. Whether they contribute to parties or not, they have legislative agendas, and they're permitted under federal law and the Constitution to meet with congressmen and senators in contexts that don't have anything to do with political fundraising, and they're going to do that regardless of what this commission does. And the third thing I would say is that these forums provided for fundraisers, if any of you have ever been to any of them, and I've been to a couple of them as a guest, not as a contributor, which Craig never hesitates to let me know. But these forums are uniquely unsuitable for lobbying activity. You're in a room full of people, many of whom have who have diverse interests to the other contributors in the room, and to stand up and say, Senator, we'd like for you to act on such and such legislation, that doesn't happen.
And finally, did I understand you to say, Mr. Burchfield, that you think the FEC has broader authority to regulate disclosure of the parties than it does of contributions and expenditures?
That is the way I would read the passage in Buckley, page 79 of Buckley. That's correct.
So you think we can go further with regulating disclosure? Require the disclosure of more than we could limit or prohibit?
I think that that the disclosure requirements that you have on political parties now are as far as can be justified under Buckley.
Thank you.
Well, we have extended beyond our schedule already by 20 minutes. Are there any commissioners who have what they would consider to be absolutely urgent questions that need to be asked of this panel, keeping in mind that we, of course, when we get to discuss the actual resolution of this rulemaking, will have hours on end to say whatever we want?
I have just
Mr. Riley?
one very quick question. What % of your donors come to these functions? You have any idea? I really don't see plane loads of people coming in for these.
I would say about a quarter of them. Depends, though, on the donor program, but I would say a quarter of them.
That's all.
Commissioner McDonald?
Well, only on that point, because I do think it's an interesting point, is that I think actually that is the issue. I don't think there are plane loads. When I see a list of $79 million by 601 contributions, and a number of these, by the way, are the same contributor if you go through the list. This is found downstairs. I do think that's a concern. I think the case actually is more compelling the other way. I wish there would be hundreds of donors show up, because I think that would be more telling. The concern, as we know from the history of Watergate, was that there were a handful of individuals that contributed large sums of money, and that was really what gave birth to the act. So I'm glad Commissioner Elliott brought that up, because I do think it's an important point.
I would say, though, that even if a quarter of our donors would attend a particular event, you'd be well into the hundreds, if not 1,000 at some of our events.
Mr. Sandstrom?
One last quick question. Does the panel believe that Austin versus Michigan Chamber of Commerce remain good law?
That was an express advocacy case, wasn't it?
Yeah, I believe so.
Was that correct? That's an express advocacy case.
It deals with independent expenditures by the Michigan
Right.
Chamber of Commerce. I was just wondering, do you believe that remains good law?
Yes, we do, and it is consistent with the Bellotti decision, which addresses issue advocacy from corporate
In
funds.
Massachusetts.
Okay, thank you.
Thank you very much.
Thank you. Yes, Roger, how you doing? Good. See you.
Our next panel consists of Don Simon, who is General Counsel for Common Cause, and Roger Whitten, who is with the law firm of Wilmer, Cutler, and Pickering, who represents Common Cause.
I'm just dying. I'd rather have tea. I bought my tea back. Yeah,
Good morning and welcome. I will allow you to proceed however you wish. Again, we would hope we can keep the initial presentations to about 5 minutes so that we can provide adequate time for questioning and back and forth.
Thank you, Mr. Chairman. Members of the Commission, my name is Donald Simon. I'm Executive Vice President of Common Cause. I'm accompanied by Common Cause's outside counsel, Roger Whitten from Wilmer, Cutler, and Pickering. Mr. Whitten was lead counsel for Common Cause in our 1987 lawsuit against the FEC seeking revisions of the Commission's regulations governing soft money. I'd like to make a brief opening statement on our general views of the Commission's proposed rule, and then Mr. Whitten will address the more specific question of the Commission's statutory authority to promulgate these rules. We appreciate the opportunity to testify today. We're pleased that the Commission has undertaken this rulemaking. There's no more important issue to the health of the American political process and to the integrity of the post-Watergate campaign finance laws than the explosive growth of soft money. The rise of soft money has distorted almost beyond recognition the Federal Election Campaign Act, which you are responsible for administering. That act and the predecessor laws which it incorporates contemplate a federal election process that is walled off from corporate and union treasury money and from large individual contributions that exceed the $20,000 gifts which the national parties are permitted to receive. The act seeks to exclude this money because in the judgment of the Congress, such money flowing to federal candidates and officers can result in corruption or the appearance of corruption and can distort the electoral process. The Supreme Court has decisively upheld the constitutionality of these limits as furthering the compelling governmental interest in safeguarding the integrity of the political process. But instead, because of soft money, what we have today is a system in which the very types of money that are supposed to be excluded from federal elections are instead playing an increasingly dominant role. We have a system in which the highest of federal officials, from the president on down, are openly involved in soliciting corporate and union contributions that now sometimes exceed $1 million in a single gift, and gifts from individuals that have been as large as $250,000. The notion that this money, all of which is illegal under federal law, is then used to affect only state and local elections is a fiction. Initially, soft money was spent on grassroots activities such as voter registration and get-out-the-vote drives that necessarily and inherently affected federal campaigns when they were conducted in federal election years. But beginning with the 1996 election, the spending of soft money to affect federal campaigns became even more blatant when both political parties used tens of millions of dollars of federally illegal funds to finance TV campaigns that praised or criticized specific federal candidates by name and were, in substance, indistinguishable from candidate campaign ads. And this practice continued in the 1998 election just passed. In our view, this use of soft money was plainly illegal. The Commission's long-established rulings have made clear that political party speech is not subject to an express advocacy test, but rather to an electioneering message test. This view has been stated by the Commission in advisory opinions that date back to at least 1984, and in the position taken by the Commission in several court cases, including in the pending lawsuit brought by the Republican National Committee and the Ohio Democrats. The Commission's position on this point is, we believe, well-grounded in the Buckley case, which clearly recognized that political parties are different and that their activities are, in the Court's words, by definition campaign-related. The premise upon which the soft money system rests, that this money is raised by federal candidates and federal office holders, but used only for non-federal purposes, is simply not credible. It's not sustainable. The truth is that under the rules and practices that have been in place for at least the last 2 election cycles, any kind of money in any kind of amount from any source could be raised by federal candidates and then spent in ways in which those candidates could be assured would directly benefit their campaigns. This has made a mockery of the federal campaign finance laws, and it's the soft money system which has been the engine driving this implosion of the Federal Election Campaign Act. The Commission has a responsibility to take the necessary steps to restore the integrity and meaning to the laws you administer. As we said in 1984, when Common Cause first asked for a rulemaking on this matter, this means first and foremost that you should ban soft money. Now, we have advocated, to be sure, that Congress act to ban soft money, but for the reasons that we set forth in our written comments, we believe that you also have the authority and the responsibility under existing law to do so as well. You should conclude, as the notice of proposed rulemaking states, that the Commission's existing regulations allow the national parties, quote, to use large soft money contributions in ways that unavoidably influence federal elections. Based on this, you should prohibit the national parties from raising soft money and the state parties from spending it on activities which affect federal campaigns. The existing soft money system is a national scandal of historic proportions. It's a mechanism for donors and candidates and parties to cheat on the federal election laws. And by conservative estimates, this cheating will amount to more than $500 million in the coming election cycle. You can stop this. You can honor the intent of Congress dating back to 1907 when it banned corporate money in federal elections, dating back to 1947 when it extended that ban to union money, and back to 1974 when it passed the post-Watergate reform law in order to arrest the corrupting influence of big money in federal campaigns. In our view, the Commission for too long has stood by idly while the federal election laws have been drained of their force and vitality by the growth of soft money. We urge you to address this problem and to act now. Thank you.
Good morning, Commissioners, and thank you for giving us the time to appear. Don mentioned that I was lead counsel for Common Cause in the middle 80s in the Common Cause versus Federal Election Commission case that bears so heavily on the issue that you're going to decide. But I wanted to, by way of answering a question that Commissioner McDonald asked to an earlier panel, I want to go back to the fact that I had the privilege of serving on the Watergate Special Prosecution Force under Archibald Cox and Leon Jaworski. And I also had the privilege to be on the briefs in Buckley versus Vallejo. So I have some good recollection of why this statute that you're charged with administering and enforcing came into being. And that recollection is an overwhelming national judgment expressed by Congress that large donations, and in particular large donations from certain sources like labor unions and corporations, have the capacity to corrupt and to create the appearance of corruption, and that fact and appearance together have a corrosive effect on the confidence of the people in our democracy. And that's what was the motivation for this act, and that in essence was the basis for the Supreme Court's decision upholding not only disclosure provisions but contribution limits. Commissioner Wald, it is true that in Buckley the Supreme Court, for purposes of its constitutional analysis, equated spending with speech. But it is also true and terribly important that in that same decision, the Supreme Court accepted Congress's judgment that large contributions carry with them the seeds of actual and apparent corruption and therefore may be regulated consistent with the First Amendment. Now, turning to the subject I've prepared to address, I want to talk about why I think this commission has the statutory authority to promulgate rules that deal effectively with the problem of soft money. Our analysis begins with the record. The record in this rulemaking, and indeed the public record writ large over the last decade, requires the Commission to make three factual findings. First is that soft money, viewed in the aggregate as it must be, is raised and spent for the purpose of influencing federal elections. In the words used by the General Counsel in the Notice of Rulemaking, soft money unavoidably influences federal elections. The second finding, which I submit this Commission must make on this record, is that soft money practices facilitate massive evasion of the FEC contribution limits, which were sustained in Buckley as serving compelling governmental anti-corruption interests. And the third finding that, again, I think this Commission must make on this record is that national party fundraising is a central feature of the soft money system, as is spending by state parties on so-called mixed activities. I submit to you, Commissioners, that it would be arbitrary and capricious for the Commission to fail to make these factual findings on this record. Once the FEC does make these findings, indeed, once it makes either the first or the second finding, it will have a fully sufficient predicate for the legal conclusion that it possesses the statutory power to adopt the rules we recommend. A finding that soft money practices influence federal elections is itself a sufficient basis for the Commission to exercise its rulemaking power to effectuate the terms of the Federal Election Campaign Act. That conclusion is clear from the language of the FECA defining the word contribution. Likewise, a finding that soft money practices facilitate widespread evasion of the FECA's contribution limits provides a basis for the Commission to exercise its statutory power to prevent such evasion. The Supreme Court has repeatedly held in Buckley, in California Medical Association, in National Right to Work, in Colorado Republican. The Court has repeatedly held that this Commission possesses statutory power to promulgate prophylactic rules where needed to prevent evasion of the Act. And in other settings, the Supreme Court and lower courts have held that federal agencies have inherent authority to issue regulations that provide a comfort margin to ensure the effective enforcement of their rules. I would submit that this Commission's statutory authority is especially clear with respect to the regulation of political parties. I simply disagree with my friend Mr. Burchfield, who's trying to read page 79 of the Buckley decision into oblivion by attempting in a crabbed fashion to narrow it to the issue of disclosure. In that section, the Court was writing broadly and writing about the definitions of contributions and expenditures, which fed into the definition of political committee. And in that decision on page 79, Buckley held that political parties fall within the core area that Congress sought to address in the FECA, because the activities of political parties are, by definition, campaign-related. That's a quote. The case I referred to earlier, Common Cause versus FEC, is direct precedent supporting the conclusion that the Commission has statutory power to ensure that all money spent by the parties that may affect federal elections must be hard money raised in conformance with the FECA. That is the only inference that can be drawn from that court's ruling that the Commission had power to adopt soft money regulations that did not permit allocation. The FEC itself has never ruled that it lacked the statutory power to ban soft money fundraising by national parties and to require state parties to fund mixed activities with hard money. Its earlier rulemaking decisions were based not on a finding of the absence of statutory power, but on a conclusion that the rulemaking record then before the Commission did not demonstrate abuses sufficient to warrant more stringent regulation. Now, we didn't, as you know, agree with those conclusions then, but who's ever right about then, the record about now is very, very, very clear. There can be no doubt today as to the existence of the abuses. And as I said, it would be arbitrary and capricious, I would submit, for the FEC at this juncture to fail to make the necessary factual findings, the three findings that I outlined a moment ago. And as I said, once those factual findings are made, they provide a complete and sufficient predicate for the FEC to exercise its statutory authority in the ways we recommend. Indeed, I would submit to the Commission it not only has the authority, but once it makes those findings, it has a duty so to act. Thank you very much.
Thank you. I'll start in the middle of the pack from the last series. I guess that would make it perhaps, I guess, Commissioner Wald. Why don't you start the question, if you don't mind?
Thank you. Mr. Whitten, thank you for your presentation. Your three factual predicates for our findings, are those in your written presentation somewhere? I was impressed with how articulate you were on those and the emphasis you put on them, and I don't want to miss the...
I think they're derivable from our written
In other words, it's back in my lap, huh? I think that would be helpful if you would. Thank you. I do have an overall question, maybe more directed to Mr. Simon, who expresses the concern of your organization of Common Cause for the ultimate effect here. And that is a concern that I have, maybe from a different perspective, though, and that, as I expressed to the previous panel, my concern is the effect of, in effect, turning or prohibiting soft money, as it's been expressed, or bringing the what are now the soft money contributions under the hard money rules. I think you would agree, or I could ask you if you would agree, that the overall effect of that would be to diminish the amount of money, reduce the amount of money that is spent in our political process, at least as it affects federal candidates. And I take it that's one of the objectives that you see in this rulemaking. Is that a fair statement?
Well, I think at that point, it's a policy question for Congress to decide whether they want to alter the hard money rules. If you did ban soft money, I think it, by definition, would diminish the amount of money the parties are spending on political activities, but only because, in our view, they're spending money on political activities in a way that was not contemplated or permitted by the 1974 law. If Congress decides that it's appropriate to increase the contribution limits in order to provide the parties with additional funds to spend in the political process, then that's a question for Congress to address.
You know, that's the appropriate area or forum in which it can be addressed. Of course, as we all know, we can't raise the hard money limits of $1,000 per individual contributor or $20,000 to political parties and the other limits. But I do have a concern with the idea that we should nevertheless address one leg of this or one aspect of this overall scheme of regulation of contributions here, when the one aspect that we might be able to address, if one agrees with the premise that we have both the constitutional and statutory authority to do that, that the effect of our addressing that side of the equation would be to lessen the amount of money that is available for communication in the political process when we don't have the authority to take the compensating step to raise the amounts of contributions that would allow the amount of hard money that is contributed to rise back up to the level contemplated by Congress when they first put in the dollar amount, the dollar limitations back in 1974. Do you have any comment on that? I mean, if it's appropriate for us to be addressing just one side of this equation when the Congress is a body that could take a comprehensive review and revision of the scheme?
You know, I do think it's appropriate for you to address this problem because I think Congress put in place a statutory scheme that in part was based on Congress's judgments about what appropriate contribution levels were, which in part depends on an analysis of its view of at what point money in the political process becomes corrupted. I think what's happened since Congress made that set of judgments is that the soft money loophole has opened up in the statute, and it's grown to the point where types of money that Congress explicitly intended not to play in the federal political process are now coming into that process in huge amounts. I think it's your responsibility to close that loophole. If, having closed that loophole, Congress wants to consider a new set of judgments about what level of contributions are appropriate in federal elections, what level of contributions may or may not be corrupting in light of inflation, in light of other factors that the prior panel mentioned, then that's a judgment for Congress. But I think your responsibility is to restore the integrity of the statutory scheme that Congress put in place.
One last question on that. If we were to take the step of adopting these regulations and prohibit soft money and thereby reduce the total amount of money that was available in our current campaign practices to use for communication to the voters, do you see any other aspect or any other players in the political process where that would take up the slack, that would increase the amount of communication? And where would people get where would voters get information from if they weren't getting it from the political parties and candidates at the levels that they're getting it from those sources now?
If I might answer, I don't accept the hypothesis that a restriction on soft money would necessarily translate into a diminution in the amount of money spent by parties to communicate to voters during elections. I don't think there's anything in the record to support that hypothesis, and I think it's highly possible that if this commission acted as we think it should, that the state parties would be more active in raising and spending money from sources permitted by state law for activities to support state and local but not federal candidates.
Thank you.
Commissioner McDonald, are you ready to jump in?
Mr. Chairman, thank you. Mr. Simon, Mr. Whitten, thank you for being here today again. It's always good to see you. Let me follow up on a few things that Commissioner Wall alluded to, and I'll start with your last comment, if I might. Do you foresee that if, in fact, you shifted the soft money to states, as you know, a number of states virtually have no limits at all on soft money, if the issue overall is one that is an appearance problem, what will the effect be if we just move it from one level to another? Do you have any sense of that and how you would come to grips with that?
I more than accept, I believe in the fundamental judgment that Congress made that large aggregations of money create the appearance of quid pro quos and sometimes actual quid pro quos. And I accept the judgment that whether it's at the federal or state level, that appearance turns voters off, and in a participatory democracy, that's the ultimate bad thing to happen. So if this were to cause states to take a new look at their own level of campaign finance regulation, I would regard that as a good thing. I think Congress, at the congressional level and at the state level, it's very important for the legislative bodies to exercise sound judgment to make sure that there is enough money, that the limits are set so that there's enough money coming into the system so that parties and candidates can effectively communicate their messages to voters and potential voters. That's extremely important as well. But I would think that by and large we could leave it to the good judgment of the experienced legislators to balance those considerations.
So let me just follow up on that by saying that we support the third variation of the second option in the proposed rulemaking, that to be effective, a ban on soft money in federal elections must include activities funded by state parties that affect federal campaigns. We think it would not be constructive in dealing with this problem to address it only at the national party level, because that will simply shift the existing soft money problem in federal elections down to the state level. So there's a need for a comprehensive approach here that addresses state party spending on federal campaign activity as well.
But jurisdictionally speaking, you'd admit that's a bigger problem for us.
I don't think it's a bigger problem insofar as the scope of your regulation affects state party spending on activities which you deem affect federal campaigns. I think there would be a jurisdictional problem for the Commission to purport to regulate state party spending on pure state activity. But insofar as your regulation is addressed at state party spending on activities which even in part affect federal campaigns, I do think you have that authority.
Commissioner McDonald, just to supplement that, I think the federal court decision in Common Cause versus Federal Election Commission, which said quite clearly that the court thought the Commission had authority to adopt rules that permitted no allocation, solves any imagined jurisdictional issue with respect to spending at the state level for mixed activities, that is, activities that conceitedly affect federal elections.
Well, you could make a compelling argument. Of course, each election cycle we always hear it's quite frequently mention that the FEC, which apparently has more authority than I think we do, has a chilling effect on the process, yet we have a record amount of money, of course, spent every election cycle. According to a report the other day on NPR, the election turnout this time, contrary to what everybody said, was the lowest since 1942. So I'm sure it's a tough thing to wrestle with on this. In one sense, I'm kind of empathetic with Commissioner Wall about the communication aspects, because that's tough too, although again it turns out the only people that are communicating are the ones with the bucks. But at the same time, clearly it's not been very effective in terms of turnout. As we know, 36 states were actually off last 2 Tuesdays ago, or what it was. 12 had an increase. I think a lot of people really didn't pay much attention to what actually happened as what they thought happened. One last comment on the other side, however, because I do think the jurisdictional problem at the state level is more severe than you envision it, at least I think that as of today. Mr. Burchfield, who's did a very good job, and I was always well prepared, are you all, alluded to a survey, I think. I don't think he would allude to the same survey for tobacco, for example, but on this survey he said that the public only had about an 8% interest in campaign finance. And you could probably make a fairly compelling argument that at least initially under the statute, of which I was glad you went over your background, Mr. Whitten, because I think it's very helpful. Clearly the issue initially was disclosure and the concentration of money, but disclosure was number one. What do you say about the prospect of two things that go hand in hand? One is that the public doesn't have much interest in it, item number one, and item number two, as long as the money is disclosed. For example, and I only use this because they were testifying, I'd use the other side if they'd testified, and I'm sorry they did not. You have a pretty thorough analysis here of where money comes from, how much money people get, when they get it. What's to say that that's not good enough for the public? How much more does the public need to protect itself, I guess, is the question I'd like to ask as the devil's advocate.
Well,
what's wrong with that?
If I can respond to that, I think we're running an experiment in that system of a kind of no limits, just disclosure regime. And that experiment is the soft money system. Mm-hmm. There is disclosure of soft money. And what we have increasingly at the federal level, as I said in my opening comments, is money coming in any amount from any source subject to disclosure. I believe that experiment has proven to be a disaster for this country. I believe that the growth of soft money is having an extraordinarily deleterious effect on confidence that the American people have in government and on the participation in the political process. I think what the experience we saw in the 1996 campaign is the best evidence for that. There were a whole series of scandals that arose in 1996 that were subsequently examined by the Thompson Committee in the Senate. And the unifying theme of all those scandals, from the foreign money donations to the sale of the Lincoln bedroom to the Roger Tamraz story to the White House coffees, the single unifying theme of all those scandals was soft money. They were all variations on the theme of soft money.
Can I ask you about that? And I apologize, Mr. Chairman, I'll quit this. It's just very important to me. Let's take the hypothesis that that's right. Now, if you drive 50 miles in any direction outside of Washington, D.C. and talk to people about hard money, hard dollars and soft dollars, I can assure you most of them are just not very interested. I'm just being honest with my experience because I've spent a little time at this myself. In connection with that, isn't the fact that they were reported and that the scandals were reported and the amount of money was reported, Isn't that what the public is to respond to? And isn't that the point of disclosure, that they in fact did know that there were vast sums of money going to these candidates from various and sundry organizations?
No, I mean, I think what you have in that system is people just continuing to lose faith in the political process. You know, you can cite polls for almost any proposition. Mr. Burchfield cited polls for the proposition people don't care. We cited polls in our written comments for the proposition that people care an extraordinary amount.
Yeah, but if I cite those, this won't be much of a question exercise, will it?
Well, but I think when you look at much of the polling that's done, when you look at what's happening to voter participation in federal elections, and when you look at what happens when people have the opportunity to vote directly on reform proposals, in this last election a couple of weeks ago, comprehensive reform proposals were passed in Massachusetts and in Arizona, which builds on reform proposals passed by initiative in several other states back in 1996. I think when people have the opportunity to vote directly on reform, they do support reform because they do care about this problem.
Thank you. I appreciate it very much.
Commissioner Elliott?
Yes, thank you for coming. Are you a membership organization?
We are.
You are. Do you advocate people going to the polls, registering and voting to your members?
We do not conduct voter registration or get out the vote drives among our membership.
But both in your publicity, both for your members and your others, do you urge people to register and vote?
I can't recall specific communications that we've sent to our members to that effect.
Do you, to your members or outside your members through news releases and all, advocate positions on various things that are pending before the Congress?
Yes, we do.
And do you accept corporate union or contributions over $5,000?
We do not accept corporate or union contributions. We do accept contributions from individuals over $5,000.
Uh-huh. Do you allocate between, in your issue advertising that goes out, between hard and soft dollars? Those that give you under and those that give you over? Do you separate those funds at all?
We are not subject to the federal campaign finance laws.
I know that. I just wondered if internally you might have done that. One other line.
I might supplement that response. Congress passed the FECA because there was an apparent risk that when money went to people who were running the government, there was a risk of actual and apparent corruption which corroded our democracy. Common Cause does not run the government, for better or for worse, and there is no plausible argument that contributions from any source to Common Cause could have the effect of corrupting our democracy.
I quite agree. I quite agree.
Well, don't be so fast.
What I'm saying is, I'm not so sure that money,
It was the UN, and now it's you guys.
not so sure that money used for speech is corrupting. That's why I agree. I do not think that there is a lot of corruption. Now, another thing. Congress, when they passed the amendments to the FECA, told us what hard dollars were. They made it very clear that they had to be within limits and they could not be from corporations and unions, and they could not be from national banks, and they could not be from foreign nationals and so on. So they gave us quite a definition. It seems to me that Congress defined soft money because it's anything outside of their definition of hard dollars. So it seems to me that it's Congress who defined soft money, and if they wanted us to have any jurisdiction over money, they would increase the definition of what we regulate, because they did that quite explicitly, and then that was more or less ratified in part by Buckley versus Vallejo. So I was interested in your testimony when it said that you think we defined soft money, that we created it. It seems to me it was created on the definition of hard money.
Well, I guess we look at things through the other end of the telescope, in a sense. I think what Congress did in passing the 1974 Act was say that money that's spent for purposes of influencing federal elections has to be money that's raised in conformance with the FEC rules. The money, what we see in the soft money system is money that is being spent for the purpose of influencing federal elections that's being raised outside of the FEC rules. The Commission created that in the sense that in a series of administrative rulings and advisory opinions in the late 1970s, the Commission opened the door to spending on mixed activities, activities that in part affect federal and in part affect non-federal campaigns, to allowing money raised outside of the FEC rules to be spent on those activities. That door has gotten pushed open much wider by the evolution of party issue advocacy, which is another means through which parties are spending soft money or non-federal money to affect federal campaigns. But that's the nature of the loophole.
Thank you, Mr. Chairman.
Well, if I could just supplement the answer. Our argument fundamentally, Commissioner Elliott, is that soft money is inside the box you were drawing with your hands and not outside the box. Because if you make the finding, as we believe you must on this record, that this money influences federal elections, you're in the box, not out of the box, and you have the statutory authority, indeed the duty, to do something about it.
Mr. Chairman.
Commissioner Sandstrom?
Stepping out of the box, I grew up in Portland, Oregon. Portland's known for one thing, rain. It's known for other things, but it rains a lot. And when you're a kid, you have to play in the rain or you don't play outside. One of the things when you're really small you tend to do is take some twigs and rocks and try to block the runoff water. And as a kid, you no matter how you try, it seems to run around what you built. And I'm concerned here whether we're running into a similar problem that I had as a child. That is trying to do address part of the problem and not the complete problem. That it seems to me our proposals before us may effectively ban soft money, or at least some of them, to national political parties, but leadership PACs would then become the recipients. And then we'd be back here in a couple of years trying to extend our dam. Now, let me end this question because I do think this is under-inclusive. I want to get your thoughts on that. But I also, growing up in the Pacific Northwest, did come to believe in dams. I did go up to Bonneville and say, when you build a dam, you better build it across the entire stream and provide for appropriate channels when the water builds up too much. So it isn't as if I think, I just failed as a 5-year-old engineer. I do think if I did learn the people who stuck to engineering could be more successful than I was. So don't you think we really have a serious problem here if we just, propose a solution that everyone can right now see how, the people who are raising the money for the national party committees could create their own committees and raise that same money and spend it for the same purposes.
Well, Commissioner Sandstrom, I guess my reaction to that point is, there are lots of problems in the campaign finance system. Soft money is a problem, phony issue ads are a problem, leadership PACs are a problem, bundling is a problem, the coordination rules are a problem. There are lots of problems, but to me that says you ought to start somewhere and do what you can. Now, some of those problems that I just mentioned can be solved by the Commission. Some of those problems have to be solved by Congress. But I think this is a very big problem, and this is a problem that you can solve. And I think it really is your responsibility to take the steps that are available to end soft money.
My question, though, would be that you're not, if the minority leader or the Speaker of the House created a committee and could take the same funds, or he created with members and took it out of the official party apparatus, it seems to me that they could raise the very sums of money in the next cycle. This is going to, it's just going to immediately have its own problem. and that you haven't solved anything because you aren't even going to decrease the flow of money.
Well, you know, then maybe that would have to be something to be addressed by the Commission and other rules, or if it's not within the Commission's jurisdiction, to be addressed by Congress. But we know this problem that is before you, and I believe we know what a solution to that problem is, and if there are additional steps that need to be taken after solving the problem before you, then those steps should be taken at that point.
If the committee you hypothesize makes any contribution or expenditure that influences a federal election, then that committee itself would be subject to the limits and couldn't accept contributions over $5,000 or contributions from corporate or union sources. So it's not quite, I'm not sure I quite see, if I remember the law right, quite see it as being a major loophole, but I don't underestimate the ingenuity of those who manufacture loopholes.
I would
Lawyers
disagree on that point, because I think they would
have a hand in
allocate
it, Commissioner.
their activities and do their media ads or doing the very same activities, and they say weren't. Before we too rush to trample on the First Amendment rights of these contributors, and I'm not saying that I wouldn't be that I'm reluctant to adopt any of these proposals. In fact, I may want to have a proposal that's more inclusive, that doesn't just single out the political party. I would note that of the 100 largest soft money contributors whose rights we might be trampling on, none of them requested to testify. Does that surprise you?
Well, I mean, I reject the premise of the question in terms of trampling on the rights of the contributors. But it doesn't surprise me in the sense that people who give soft money, the people who make these million-dollar contributions to the parties, I don't think want to be subject to questioning about why they are making those donations.
Would it surprise you that if you added up these 100 in the 95-96 cycle, about $150 million from just 100 contributors?
No.
That's a lot of speech that we'd be regulating, correct?
Speech by the contributors?
Yeah. Or by proxy through the...
Well, I mean, you know, speech by proxy, as the Supreme Court pointed out, is a lesser protected form of...
And maybe that's one of the reasons, because it's by proxy, they don't feel as strongly about this, and therefore may not have asked to testify on maybe that a partial explanation why they didn't ask to testify, because it's not even directly their speech.
Well, the Supreme Court has made it clear in any number of cases that that Congress may constitutionally limit the amount of contributions and may altogether cut off the right of certain organizations like corporations and labor unions to make contributions in connection with federal elections or expenditures. So,
yeah, follow up on that. Isn't it also a lot of these people who are being asked to contribute these large sums of money may not actually like the system? Some of them actually, and may not even want to speak against the system because they're put in a very difficult bind.
Well, I think that's right, Commissioner. In fact, I think one of the things we're starting to see is something of a backlash from the soft money donor community because looked at one way, the soft money system can be viewed as a form of bribery of federal officials. Looked at another way, it can be viewed as a form of extortion by federal officials. And I think that increasingly there are voices in the business community who object to the way the laws work because they feel that they're subject to a form of shakedown by federal officials and by the parties to have to contribute huge sums of money in order to gain access to elected officials.
So it may be that few tears are shed in these organizations if we come up with a more effective bar on soft money contributions.
I think that's right.
Commissioner Mason?
Well, I have lots of questions, but I'll try to keep them short. I have a couple that you're not going to want to answer yes or no, but try. Number one, for
That'll be Don's job.
for Mr. Whitten, sorry. You discussed your 1984 petition, your 1987 lawsuit, and your analysis of factual findings, which you said we had to make. I take it I don't have a choice about that, and I'm an automaton, and the facts are in, and you've made my choice for me. But then that if we fail to do this, it would be arbitrary and capricious. So can I take it from all of that if we fail to adopt your recommendation, you plan to sue us again?
I would predict we would sue you again. We don't have a plan.
All right, I just thank you for that brief answer. I wanted to get it on the record. Second, there was some discussion, I think, prompted by Commissioner Wald about the trade-off between hard and soft money, and I just say, by virtue of observation, Craig Engel wouldn't say it. I'll say it because I've said it before. I believe that if we raise the hard money limits, that the amount of soft money would decrease. Obviously, people wouldn't necessarily go out of the business of raising soft money. For Common Cause in general, since we can't reach both sides of that equation, if the Commission were to ban or maybe I better put it, restrict soft money contributions to political parties, would Common Cause support an increase in the hard money limits?
To parties or to candidates?
To parties.
We have supported legislation on the Hill that does include some increases in hard money limits to the political parties.
On the point about Buckley, page 79, and so on like that, how do you, Mr. Whitten, how do you get around the passage in Colorado Republican which refers to the FEC construing it as permitting soft money contributions in connection with state elections?
Well, this isn't a yes or no, is it? No. Yes. Commissioner Mason, Justice Breyer's comment was, first of all, an aside, and second of all, was made in the context of a case involving expenditures by state parties, and I think is viewed as a comment about what state parties can do, and I think we would all agree that state parties can use soft money to for the purpose of influencing state and local elections.
Lastly, this is really just an observation on my part, though if you want to comment briefly, feel free to, and that was in regard to, I believe Mr. Whitten used the phrase comfort margin, that federal agencies were entitled to have a comfort margin, and I see the problem with us setting rules and people learning ways around the rules, and so you set new rules to try to deal with that. That's fairly common practice among federal agencies. I don't see the proposals laid out before us as being really in that range. But my problem with that and with this question of state parties and anything that affects federal campaigns is our entanglement with the First Amendment. And I just wonder whether, in fact, we aren't a bit more restricted than a comfort margin by the various requirements that we use the least restrictive means, that it be narrowly tailored and so on like that.
I think there's some learning in that in, for example, the California Medical Association case. I think even in the context of the Federal Election Campaign Act, which operates in a First Amendment context, that the court has, in that case and others, said that this Congress and by extension this Commission have authority to act in prophylactic ways to prevent evasion of the core provisions of the legislation.
And let me just make two other observations and just sort of underline 2 points that we've mentioned before. First, we're dealing solely in the realm of contributions, and the First Amendment interest the court has repeatedly recognized is of lesser weight when we're talking about contributions. And I think that correspondingly gives the Commission more latitude without invoking First Amendment concerns. Secondly, specifically to the concern about state parties, as long as you operate within the box of state party activities that affect federal campaigns, I think you are squarely within your jurisdiction. State parties under existing law are required to use hard money, federal hard money, for federal election activity. The only thing the regulations propose to do is clarify what the scope of state party activities are that do impact federal elections. And I think that's comfortably within the existing jurisdiction that the Commission has over state parties.
I think I disagree, but I won't pursue it at this point.
Let me just make a couple of brief comments and maybe ask a short question. First, I couldn't help but admire your reference to Tom Harris in your footnote 13. I think he saw long ago, back in 1978, when the Commission took the different approach in Advisory Opinion 78-10, that we were in for trouble. And I think he probably is getting a kick out of this hearing as we speak. The question I guess I would ask you, and it's sort of in the vein of a devil's advocate question, why isn't it adequate to operate under a system where the folks raising soft money have to provide clear and express notice that that money that's being raised and being called soft money is going to be put in the party's non-federal account and used only to pay for non-federal candidate support or the non-federal share of generic party-building activity? Why isn't that sufficient in and of itself?
Because the premise of the question is a fiction, that what we see today is the money spent out of the non-federal accounts is spent for activities which do affect federal elections, whether it's get out the vote drives or the so-called party issue ads, the phony issue ads. Those are activities which do affect federal elections. And so the whole structure of the current regime that you have these two separate accounts and that the money taken out of the non-federal account somehow impacts only non-federal elections is simply not factually correct.
And how about the recommendation of some that maybe we could do our job adequately if we just put in place some sort of prohibition on federal candidates being involved in raising soft money? Why isn't that sufficient insulation so that they're not then rubbing elbows, say, at these big party fundraising events with the largest soft money donors?
Well, you know, that would go a small part of the way and perhaps remove the very worst forms of the appearance of corruption, but you would still leave in place a system where the national parties and the national party officials would be raising money from donors who have great interest in the decisions of federal officials, raising money far in excess of the FEC limits. And you would still have the national party spending that money on activities which affect federal elections. The basic loophole would still remain in place.
Do you share the hunch that I have that even if federal officials weren't involved in raising the money, that somehow they would be informed of the party's big donors, and somehow with regard to what the parties ended up doing to spend the money, they would be fully aware of who has made the big soft money donations to support those ads, for example?
Well, that's right. So the harm that we see from the current system would not be effectively diminished much at all.
The record of the Thompson Committee hearings shows unequivocally in more than one setting that fundraising, those charged with heading up either the Democratic or the Republican National Committee have a way of reporting back who's giving the money. And some very unfortunate appearances of connections between contributions and federal action are inferred from those circumstances to the detriment of all.
Thank you. Larry Noble?
Thank you. Mr. Whitten, based on your response to what Mr. Burchfield said, I take it you believe that the FEC's jurisdiction over disclosure and limitations and prohibitions is coextensive. They're both the same.
Yes.
The NRSC testified that soft money contributions have no effect on legislation, that there's no evidence that they have any effect on legislation. Does Common Cause have a response to that?
Well, yes. We think that making that statement reflects a very naive view of the world and a very naive view of the Congress and a very naive view of the way Washington works. We included in our written testimony some examples of situations where we think very large contributions by affected industry groups did have an impact on legislative results. We have done numerous studies drawing similar sorts of correlations, and I'd be happy to supplement the record. But, you know, if you look at patterns of soft money donations, and I believe someone before raised, for example, the millions of dollars that the tobacco industry has contributed to the political parties at a time when that industry has enormous interests pending in Congress. I think, again, it's naive to think that that money is not being donated by the industry with an eye towards, at a minimum, buying access to federal officials and more realistically trying to influence the legislative results.
There's a wonderful book, if I remember the title correctly. It's Speaking Freely, and it's interviews with former senators and congressmen who are speaking freely because they're no longer in the Senate and the House about the corrosive effects of contributions and fundraising on their activities, how they spend their time, how they conduct themselves, what they do. And I think that provides material that would help answer your question, Mr. Noble.
And finally, much has been made of the argument in the comments that that there has been some attempts in Congress to ban soft money, and those attempts have failed, and therefore the FEC should not tread into the area where Congress is either considering it or has not been able to pass such laws. Do you have a response to that?
Well, I think that's looking at the problem backwards, essentially. I think Congress did not intend the soft money system we have now. I think it's not permitted under the 74 Act. I think it's a problem created by the Commission in its interpretations of the Act, and I think, therefore, the Commission can and should close that loophole. If the Commission doesn't, then certainly Congress also has the authority to do it, but the fact that Congress hasn't acted, I don't think is any indication that it doesn't want the Commission to do so. And I would also note parenthetically that legislation to end the soft money system last year received majority support in both the House and the Senate. It was blocked only by a filibuster conducted by a minority of senators.
Thank you. Further questions?
Any other urgent questions for this panel? Commissioner Sandstrom?
Do you know, with respect to the original, the Tillman Act and the investigations of the 1904 election and the 1900 election, the 1896 election, the monies that were donated by corporations, who the money or what entity that money was contributed to?
I don't know.
I was here during Watergate, but I was not here during the 1904 election.
But would you be, Charles Evan Hughes was. He did an investigation, and would you be surprised to learn it was actually contributed to a national committee?
Shouldn't surprise me at all.
Thank you.
Thanks, gentlemen.
Thank you.
If we don't see you in court over this, we'll probably see you in court over something else. we enjoy our relationship over the years. You
Thank you all.
keep us on our toes. We'll take a 5-minute break, and we'll then welcome our next witness, Mr. James Bopp.
You're in favor of 2- option 2. Right.
We'll continue with this forum on financial contributions to political campaigns in a moment. Later at 12:15 a.m., results from today's House Republican leadership elections. You'll hear from the GOP's nominee to be the next Speaker of the House and others. Following that, brief comments from the start of a meeting of the Republican Governors Association. At 1:10 a.m., Senator Joseph Biden talks about the impeachment process. Tonight on our companion network, C-SPAN, you can hear about 5 hours of the audio tapes that Linda Tripp made of her conversations with former White House intern Monica Lewinsky. That's coming up at 11 p.m. Eastern over on C-SPAN. Tomorrow morning, the House Judiciary Committee begins hearings on the impeachment charges against the president. Independent counsel Kenneth Starr will testify. Tomorrow's hearing is scheduled to get underway at 10 a.m. Eastern. You can see it live on our companion network, C-SPAN. And this programming information, on the days the Judiciary Committee conducts their impeachment hearings, we'll replay them for you at 7 p.m. Eastern. That's also on C-SPAN. Now more from today's meeting on soft money contributions to political campaigns. The Federal Election Commission hosted the event. This portion's about 2 hours.
We next will hear from Mr. James Bopp Jr. He is here on behalf of the James Madison Center for Free Speech. We are familiar with Mr. Bopp. He enlightens us on most of our ongoing rulemakings, and we're happy to have you. Please proceed.
Thank you very much, Mr. Chairman. I would like to address my oral remarks to the question of whether or not the Commission has the statutory authority to limit soft money contributions and expenditures by political parties. Now, the regulatory authority of the Federal Election Commission is limited to, of course, its statutory authority. That is, any action by this Commission that is, quote, beyond the statutory authority, end of quote, of the Federal Election Commission would be void and is subject to being declared so by a competent court of law. Now, unfortunately, the regulatory history of the Commission has indicated, at least in certain areas, an unwillingness to limit the effort by the Federal Election Commission to expand its jurisdiction to what has been authorized by Congress pursuant to the Federal Election Campaign Act. And in particular, the Commission has engaged in a series of unsuccessful rulemakings trying to suppress issue advocacy by citizens groups, particularly corporations and labor unions. The result has been a series of regulatory enactments seeking to limit issue advocacy that have been declared unconstitutional and beyond the statutory authority of this Commission. Specifically, the Commission has adopted 2 regulations trying to limit voter guide distribution, which have been struck down in 2 separate cases, Foucher and Clifton. The Commission has adopted limits on voting records published regarding incumbent members of Congress, which was struck down in Clifton. This Commission has adopted a definition of express advocacy that it would encompass issue advocacy that has been struck down in 2 separate cases by the First Circuit in Maine Right to Life Committee and the Southern District of New York in Right to Life of Dutchess County. Each of these efforts have been directed at issue advocacy by certain organizations. Now this Commission is again called upon to suppress issue advocacy by the proponents of the limits on soft money that this Commission is now considering, this time issue advocacy done by parties. Now, the problem, it seems to me, in terms of the statutory authority of the Commission to limit soft money contributions, is the fact that the Federal Election Campaign Act itself is limited in its application. It is limited in its application in the definition both of contribution and of expenditure to anything of value, quote, for the purpose of influencing any federal election. This, of course, has led the United States Supreme Court and Colorado Republicans to state that the FECA permits unregulated soft money contributions to parties for certain activities, such as electing candidates for state office, or for other voter registration and get-out-the-vote drives. It led the 1987 District Court decision court in Common Cause versus FEC to say, quote, "It is clear from the statute as a whole that the FECA regulates federal elections only. This limit on the FECA's reach underlies the entire act." And it also led the court in United States versus Charlie Tree to conclude, quote, "The word contribution is a term of art defined by the statute, and the statutory definition applies only to elections for federal office," citing 431A8. It therefore does not encompass soft money donations. Now, interestingly, this commission acknowledges in its proposed rulemaking that soft money contributions are beyond your own authority. The very first sentence of the summary of the proposed rulemaking states, quote, "The Federal Election Commission today seeks comments on proposed rules relating to funds received by party committees outside the prohibitions and limitations of the Federal Election Campaign Act, also known as soft money." This is an admission on the part of this commission that the very rulemaking that you're engaged in regarding soft money is beyond the Federal Election Campaign Act. Now, logically, that is true. And that is true, as this commission acknowledges also in the notice of proposed rulemaking, that another, in addition to federal elections, that another dominant focus of national party committees is advocating issues and electing state and local candidates, although the level of direct involvement in non-federal election varies among the national party committees. Thus, the commission has acknowledged that national political parties as well as state and local political parties have a purpose and have a substantial activity with respect to non-federal races, whether they be generic discussion of issues without advocating the election or defeat of any candidate, or direct or specific involvement in state and local races. With that activity being subject to the proposed ban on receipt of soft money contributions, this commission would therefore be prohibiting activity that is beyond the act, that is, the raising and spending of money that is not for the purpose of influencing a federal election. It seems to me then that the core proposal in core number 2 is clearly beyond the act, and therefore the only answer that this commission can give, absent amendment by Congress of the Federal Election Campaign Act expanding your jurisdiction, is that this is a matter for Congress to do, not for you to do. Now, the only, it seems to me, colorable argument that would encompass your jurisdiction is made both by Common Cause, as we just heard, and also by the proponents of Shays Meehan, who will testify later, and that is that the phrase influence an election is broad enough to encompass a wide range of activity that might have an impact on federal elections, and therefore you can find that for instance, issue advocacy influences federal elections and therefore encompass it within your jurisdiction. I think the problem with that is the simple refusal of the proponents of that point of view to recognize the First Amendment limitations that have been imposed on the Federal Election Commission and has resulted in a series of limiting constructions on the provisions of the Federal Election Commission. When you listen to Common Cause, or you will listen to the Brennan Center and Shays Meehan, it's like we're talking about the ghost of Christmas past. In other words, we're talking about what did Congress intend when they said influence an election back in 1974, as if the First Amendment is not the supreme election law in this country, but that the Congress's intent overrides the First Amendment, overrides the protection of free political speech, and therefore can be used to trump the protections of the First Amendment. They don't cite any cases about where the phrases such as relative to, in connection with, influence an election, all of which in Buckley versus Vallejo and Mass Citizens Concern for Life were interpreted to be limited only to express advocacy of the election or defeat of a candidate, and not to encompass issue advocacy, as of course this proposal seeks to prohibit issue advocacy done by political parties. Nor do they cite the series of cases, including First National Bank versus Bellotti, which held flatly that corporations can engage in issue advocacy without limit, that corporations are not a corrupting source of issue advocacy, the discussion of issues of public concern. They don't cite Citizens against rent control versus Berkeley that struck down a $250 limit on what can be contributed in order to engage in issue advocacy. In other words, and then they don't cite Mass Citizens Concern for Life, that in the context of the Federal Election Campaign Act made a clear distinction between expressly advocating the election or defeat of a candidate or issue advocacy, which was protected and outside the 441B corporate prohibition. Nor do they cite the provision of Buckley on pages 78 through 80, which as Bobby Burchfield pointed out, was the reporting of both contributions and expenditures in the original version of the 74 Act before it was amended post-Buckley, and that in those passages limited the reporting of these contributions and expenditures. If it was to pay for a communication, limited those to only expressly advocating the election or defeat, dealing with these very words influencing an election found in both the definition of contribution and the definition of expenditure. So the effort by the Commission to attack issue advocacy is just simply destined to crash upon the rocks of the First Amendment. It's a siren song to think that political parties can be disadvantaged, can be treated differently, that their issue advocacy is somehow or another subject to limitations, that the Supreme Court has made perfectly clear may not be placed on corporations, labor unions, individuals, nobody else in the political process. Which then sort of brings you back to the latest Supreme Court case, Colorado Republican Party, which instructs that as opposed to political parties being somehow or another more evil and more subject to limitation, held the exact opposite. The court said that, quote, the independent expressions of a political party's views is core First Amendment activity, no less than the independent expression of individuals, candidates, or other political committees. And went on to say that political parties, as opposed to having a increased or heightened threat of corruption, in fact was the opposite. They said that rather than indicating a special fear of the corruptive influence of political parties, the legislative history of the Act demonstrates Congress's general desire to enhance what was seen as an important and legitimate role of political parties in the American elections. The court then concluded that this court's prior case law controls the outcome here. We do not see how a constitution that grants individuals, candidates, and ordinary political committees the right to make unlimited independent expenditures could deny the same right to political parties. And of course there they were dealing with express advocacy, election or defeat, which as I also pointed out, we're not talking about even issue advocacy, that is, which is entitled to heightened protection, which can be engaged in by corporations. If they want to themselves, they can give money to political parties. They can engage in the very same speech, that there is not a prohibited source, there is not prohibited activity, but indeed is activity that is necessary to preserve our representative democracy. So it takes you both taking into account the constitutional concerns and the plain language of the Act, a prohibition as considered in the core proposal number 2 is beyond the statutory authority of this commission.
Thank you. I'll start this time with Commissioner Sandstrom, I believe.
Good morning.
Good morning.
You present a formidable argument. I understand that one of our staff people that I've got to know used to work for you, and you can rest assured he presents formidable arguments here. But let me just clear up. You're with the James Madison Center for Free Speech. We represent.
That is the context in which I'm speaking today.
Okay.
Yes.
President Madison was a good Democrat. He didn't endow the center, did he?
No.
Well, I
wish
just
he
wanted to get that clarified. That
and we do have an 800
It doesn't
number.
indicate his endorsement of the views.
That's good.
Would you concede that national right-to-work case remains good law?
Yes.
Would you concede that CalPAC remains good law?
Which part?
The major holding.
I mean, the holding that the $5,000 PAC
Yes.
contribution limits constitutional. That was only a holding of a plurality of the court. It was not a holding in the majority of the court. So it is only
So you
entitled to the deference that plurality decisions are made, are given, which is not binding.
Okay. With respect to Austin, would you concede that remains good law?
Definitely. And of course, Austin involved, express advocacy, election or defeat, but you have to read Austin in light of MCFL, and that is that while you can prohibit corporate express advocacy if done by business corporations, you cannot prohibit, nor is there any corrupting effect of issue advocacy by even business corporations.
Okay. Then, would you? In Justice Marshall's opinion, he writes, the state's decision to regulate only corporations is precisely tailored to serve the compelling state interest of eliminating from the political process the corrosive effects of political war chests amassed with the aid of the legal advantages given to the corporation.
And that is true as to express advocacy.
But it also is true with respect to contributions.
It would be true with
political
respect
committees.
to contributions as well from business corporations.
Okay.
Yes.
Do you agree with the holding in Beck versus CWA?
Yes.
Do you believe that holding actually should be extended to the beneficial shareholders of most of our major corporations?
If the purpose is to use funds for expressly advocating the election or defeat of a candidate, and if we're talking about a business corporation, then I would agree.
How about contributions to a political committee?
No.
They shouldn't apply.
No.
So,
no, because as Mass Citizens pointed out, even in the context of a not-for-profit corporation, which Mass Citizens was, people who contribute to Mass Citizens do so because of the political ideas that Mass Citizens is advancing. Similarly, political parties advance political ideas, and therefore people who contribute to them are doing so for a broadly defined political purpose.
I'm talking about corporations that contribute to them.
Corporations or individuals. I don't see...
You don't see any distinction between a corporation and individual contributing?
Well, in which respect?
In the
In what
respect that the corporation enjoys certain advantages given by the state, that the individual shareholders, particularly the beneficial shareholders, have no ability to influence whether they contribute or not. In fact, they're forced to subsidize speech.
If the money is being used for issue advocacy, First National Bank versus Bellotti settled this issue that you just described. That it does not violate the rights of shareholders or anyone else. It does not corrupt the political system for corporations to be engaged in issue advocacy.
Did Bellotti involve corporate contributions to political parties?
No, it involved corporate expenditures for issue advocacy. And what I'm saying is if the contribution is being made to whoever for purposes of issue advocacy, such as soft money contributions to political
Are the contributions in any way restricted?
Yes.
By the contributor, or is it a choice of what account and how it's used, whether to advocate a state election or issue advocacy? Isn't the same account used by the party to promote a state election officials, state candidates, and is used for issue advocacy?
In some cases, I assume, but a donor can exercise that control. I mean, the donor can say, I'll give you this money for only this purpose.
Is it your experience that when contributions, soft money contributions, they are so restricted and are so they cannot be used to support state and local candidates?
I don't know, but they could be. And if there is an evil that you think needs to be addressed here, banning soft money is not the most narrowly tailored answer. The narrowly tailored answer would be to require the political parties to inform their donors what the purposes are going to be for the contribution.
So if they passed the Tillman Act originally as an effective ban on, intending it to be a ban on contributions to political parties, you don't think that gives us the authority to, since the abuse that was demonstrated during the hearings were contributions to a national committee?
For federal elections. Your act says contributions for federal elections.
I believe the 441B doesn't read that way.
Which one?
441B, the ban on corporate contributions, says in connection with a federal election.
Okay, but the word contribution is defined in 431.8, which is the definition that is used throughout the Act, and it's for purposes of influencing a federal election.
Contribution in 441B, predated the definitional sections in the 1974 Act.
Well, that may be, but the word contribution and the word expenditure are terms of art that are applicable to federal elections. In other words, the Federal Election Campaign Act was not established as giving a federal agency the authority to regulate state elections. And no one has ever suggested that making a corporate contribution to a state party for state party purposes is a violation of the Federal Election Campaign Act.
And I don't think the proposal we're discussing does that.
Well, if it prohibits
if it implicates both federal and state activities, we can go with the federal rule because the allocation really doesn't get at the problem. The allocation goes to the expenditure side and not the contribution side. I don't think the appearance of corruption arises with how you allocate expenditure, but the sources of your funds.
Well, if a national party raises funds to make contributions to state candidates, and they have a fund for that, all right, and that fund under state law, there can be corporate contributions in that fund because it's legal under state law to make corporate contributions to state candidates. That fund has absolutely nothing to do with influencing federal elections. But the proposals here would ban political parties from having such a fund. And what I'm saying is there is absolutely no statutory authority for the Federal Election Commission to tell states whether they can accept corporate contributions for state candidates or not. And that would be the effect, at least as to national parties exercising their goal of electing state and local officials as well as federal officials.
I don't think depending on how the proposal comes out, I don't think there is such an intent. But you have an activity that actually mentions both. You might be able to say it has to be paid exclusively from federal funds because you can't separate the actual benefits out, and that any allocation method, fails to do that adequately, and it really doesn't get at the heart of the problem is that, federal candidates are raising money for the purpose of influencing their election, and from that the appearance of corruption arises.
Well,
I thank you.
Proposal number 2 would prohibit the exact fund I just described because all funds would have to be raised under the Core 2 subject to the limitations and prohibitions of the FECA. The political party could not receive a corporate contribution into a fund that was specifically designated to make contributions only to state and local candidates. That would be unlawful under Core Provision number 2. So you would have to at least begin to make exceptions.
I think wise exceptions should be found in what we finally do. I think if we can come to that wisdom, we should go ahead and do something in this area. Thank you, Mr. Bob.
Thank you.
Commissioner Elliott.
Thank you very much. I have read your testimony, so I know how you feel about the law and the cases that have followed the enactment of the 74 amendments in Buckley. But now I'd like for you to really look at this as if you were advocating the General Counsel's position that we could make this change in the law. Now that's taking you in exactly the opposite direction. But the question I'm going to ask is, if we could so change the scope and the reach, as you mentioned, of the act, could then we just change the caps and lift the limits also, if we can do all that?
Yeah, you don't have authority in your rulemaking to affect what the act encompasses. And I mean, in order to do what core proposal number 2 proposes to do, you would have to amend both the definition of contribution and expenditure. You'd have to delete the phrase "for the purpose of influencing federal election," and then you would have to say "for any purpose." Well, I'm trying to think. For it would be for for any purpose relating to any election, and you would have to then Congress would have to try to prevent the courts from imposing First Amendment limits on the reach of that proposal. I mean, one of the reasons for the express advocacy test is so that the speaker, in this case the spender, knows whether they are spending something for an election, whether they're spending it for a non-election, like, for instance, a referendum, a ballot initiative. Many political parties spend money for ballot initiatives. That's not a candidate election. So you've got one ambiguity there. Whether or not it's for federal or state elections. Whether it's issue advocacy or candidate advocacy. And what that vagueness has caused the courts to do is to say, look, we need a test that the speaker knows. So political parties would still be, even in the broadest type statutory language that you could think of, the political parties would still be at a quandary of whether or not, for instance, they spend money on a ballot initiative is now spending money that is prohibited because it relates to a candidate. And so you would be still up against the necessity of the courts to give limiting constructions in terms of the content of the speech.
Okay. Now, let us say that it was decided that corporations that would express themselves on issues were covered by the act because they were talking about things currently in a campaign. Would that mean that their lobbying activities would be, when they had their representatives speak directly to the congressman, that would come under our authority?
Not only that, but if they talk if they in particular talk to the general public about, there's a pending bill, we want you to lobby your congressman or senator about how he or she should vote, that would clearly come.
So grassroots lobbying would come under our authority under that.
Yes, and of course that's the second reason for the express advocacy test, is the court found that that is overbroad, that under the Federal Election Campaign Act 441B, Congress could not, consistent with the First Amendment, give this commission the authority to prohibit issue advocacy by corporations that encompass things like grassroots lobbying.
Thank you very much. Thank you, Mr. Chairman.
Commissioner McDonald.
Mr. Chairman, thank you. Jim, it's good to see you again.
Thank you.
I'm just not quite clear where you stand.
I hope that would be the first time.
It would be, of course. I am glad you're here. It's a good discussion to have. Let me just go back. One of these days I'm going to do this, but not today. I'm just going to read back all the cases that we've won because I'm pretty well familiar with the ones you've cited. But I'm in a very serious vein. You've been pretty critical of the commission, and rightfully so, from your perspective about pursuing court matters. And you mentioned you here in the context of the James Madison Center today, but certainly in other contexts, you pursued court decisions that you didn't think were actually satisfactory, even at the Supreme Court level. Have you not?
Yes.
The reason it's important is I think that when we discuss these matters in a generic sense, it's important for the listening audience to understand that all of us pursue what, at the end of the day, we think is right, whether we agree with a particular court or not. I think you have, as have we, and I just want to be sure we were in sync on that, and that you, too, had pursued matters that didn't necessarily turn out to be like you had hoped they'd be.
Sure.
In a broader context, everybody takes
I've never
Buckley.
suggested you don't believe in what you're doing. I am just suggesting that a proper consideration of the Constitution provides limits.
No, I understand, and I would take the same with you. I thought the inference was, at least, and maybe I misunderstood the inference, that it would be a waste of time. And of course, as I indicate, I think you've pursued areas that people would say the same to you, but you would think legally that's not necessarily the case in the final analysis. But
Well,
more specifically, if you don't mind, I'd like to get to, everyone quotes Buckley and they take the part of Buckley that they are most enamored with, and they have a interesting analysis of it. But by and large, one of the things that nobody ever seems to say, which I find kind of interesting on all sides, is that what Buckley really did was uphold the law. And what Buckley really did was have limits. And when the issue about free speech comes to pass, I don't, to be honest with you, and I can only speak around the state, but I can't speak anywhere else, I don't know anybody that's not for free speech. As I said earlier this morning, it turns out that political speech is not very free, but that aside, I would concur with you. I think everybody ought to be exceedingly strong for free speech, and the issue really gets to be a little bit more fundamental than that. One, it gets to disclosure and issue advocacy, as you may well appreciate. I think it also gets to both disclosure and then going back to what Commissioner Sandstrom said, what the limits, starting with the Tillman Act and coming up through the Corrupt Practices Act, the Taft-Hartley Act, all of those things that were encompassed, that's where it was trying to get to. My question is this: is it your opinion that overall that the law is unconstitutional on its face, the FECA?
No.
And why would that not be? It's a pretty strong restriction on what we have examined here this morning as free speech. Why would you think it is not?
Because parts of it are justified
And
by compelling interest.
And those would be?
Well, the prohibition on business corporations doing IEs or making contributions is justified by the potential, as stated in Austin, and of course a whole line of cases that corporations pose a risk of corrupting the political system by spending money raised in the economic marketplace on political ideas, on political campaigns. But that, you know, that is a limited holding, as the First National Bank of Bilotti explained. It doesn't apply to issue advocacy, as Mass Citizens applies. It doesn't apply to issue advocacy. I think that disclosure, that there's justifiable interest in disclosure of contributions and expenditures that supports that minimal intrusion. I think that that at some level of contribution there is a bona fide and provable risk of corrupting candidates by you know, giving them a raising the specter of quid pro quo exchanges between a large contributor and a candidate that would justify limits on large contributions. So well, I mean, there are several that I would support.
Would you, I mean, what would that limit be? I think you were here earlier. Just looking, I'm just trying to understand the concept more than picking on anybody. I'm not even sure I agree with you about the analysis of the corruption issue, at least the appearance of it. $79 million given by 601 transactions, and by the way, a number of those can be lumped together. What's your sense of that? Do you think that that's a problem, or is there a dollar amount that if a corporation or a labor union or individuals gave would create an appearance problem, and particularly in view of the fact that at the federal level we have, which I think everybody grants, pretty low limits?
Well, there's several ways of pulling that apart. One is to look at, how large is large. And number one, Buckley said that we're talking about an individual contribution, in other words, single contribution, not aggregating all the contributions made by a single entity to all possible players in the political system. We're talking about individual financial contributions. To look at what is large, in 1974, when the Federal Election Campaign Act $1,000 limit was adopted, the average congressional campaign was $80,000. If you got a husband and wife that gave $2,000, you were well on your way of all you needed was 35 couples to raise the entire amount. Now we're talking about competitive races of 500,000 for congressional seats and the same $1,000 limit. I just don't think that the $1,000 today is large, that poses a bona fide and provable risk of a quid pro quo corruption. Now, it may be when given to a candidate,
I would agree.
It may be. There's been attempts to try to quantify this. Professor John Lott did a study where he tracked the voting behavior of people who were in Congress but not running again for election. And he eliminated those who are running for other offices and seeking appointments to presidential positions and things like that, and found that that contributions from groups, meaning collective contributions from like all labor unions, to this person who's no longer needs any contributions, that their voting behavior didn't change, even though they had no prospect for future contributions. That, which just simply proves what other studies have shown, is that people give money to people because those candidates already agree with them. They're expressing their support for something that already agrees with them.
Did the study follow up and see where they went to work afterwards?
Yes.
Or did it?
Yeah, he tried to control it very well and ended up with like 700 examples. But people give money to, people, put it this way, people are foolish to think that you can give money to a candidate and buy their vote. Now, change their mind because you gave them money. Now, it does happen, and we need bribery laws for that purpose. But the vast majority of contributors are savvy enough to know that, that they ought to only give to people who already support their position, because that's the only time that you can really rely that they will stick to it, is when they actually believe it.
And those that give to both sides, they just really don't quite get the drill.
Both sides can have the same position on an issue. That doesn't explain anything. I mean, there were both Republicans and Democrats that supported NAFTA. There were both Republicans and Democrats that opposed NAFTA.
No, I meant in the same race. That's what I was referring to.
They may have the same position.
Could have, yeah. That'd be a good study. Let me just ask you one last thing, if I might. And we are grateful for the colleague you sent to us. He's done a very good job, I'll confess right up front. And thank goodness he hasn't recited all these cases to me, but I think he will over time. I guess the last question is this. Why we're really here is not, I always kind of feel badly about inflammatory remarks of suppression and so on and so forth. I'm not very interested in suppression. I've been a lot of places around the globe, and I actually kind of showed up there on a different basis, and suppression wasn't one that came to mind. I have been pretty interested in how money plays in American politics, and is it your position that all the soft dollars, for example, and I only took it out because they were the first ones to testify, do you figure out of this $79,916,562 that was in soft money at the national level by a committee in the 95-96 cycle, is it your position that that money does not go to influence federal elections?
No, I think some of it does. I think issue advocacy influences elections generally and can influence specific federal and state elections. And Buckley explained that in page after page, that they recognize that issue advocacy can influence an election. But in order to have a bright line rather than a vague law, on the one hand, and secondly, and in order not to encompass the discussion of issues that are critical to our representative democracy, that even though they may influence elections, they are still protected and cannot be prohibited. And all the courts that have been dealing with this thing has been recognizing, you know, a need to hold very closely to that view, so I think that's why they do it.
You wouldn't have any trouble with the Congress changing the law in relationship to soft money?
Well, it would change the problem that you have, in my opinion, that you do not have the statutory authority
Yeah, I appreciate
expand
that, but
on
how
it.
about you in Congress? Would you be for that?
Be for which?
If Congress changed the statute, you wouldn't have a problem if they either gave it to us or did something else banning soft money altogether?
I would indeed have a problem, because I think that from a policy perspective, that parties have a legitimate role, national and state and local political parties have a legitimate role in advocating issues. As I explained in my written testimony, parties were founded to advocate issues, not just to elect candidates, and that they should not be disadvantaged. I mean, it's almost ironic or perverse that political parties that were created to advance political ideas would be subject to greater restrictions than would be special interests, you know, Microsoft, who can spend, you know, advocate without limit, without allocation, without anything, you know, billions of dollars advocating issues that concern them. I don't understand a system that would say that people who join together for political purposes are subject to more restriction on discussion of political ideas than those who are not so joined together. I think it turns it on its head.
Well, I think you made an eloquent argument, and I must say that at least in relationship to issue advocacy groups, you have my vote. I agree with you, and I do think they're totally unregulated, and they play an unbelievable role in the process. Thanks again. It's good to see you as always.
Commissioner Mason?
Thank you. I suppose I ought to join in thanks for the staff. Though I now see he's been down the hall talking to the Democrats.
He's proselytizing. Is that right?
Don't worry, it's not about issues. It's just where to eat.
I think you've raised an important point as to this issue of for the purpose of influencing, and properly pointed us to the real question being the extent of our jurisdiction rather than some sort of proposal to move lines around. I mean, that's what I find curious about both the whole issue and about the way it was stated, i.e. that it was not presented as, for instance, a revision of the allocation rules, either by encompassing what was subject to allocation or not, or by changing those percentages, which would have been, at least within some limits, clearly within the authority of the Commission to address. That is to say, to adjust those up or down within some reasonable limits, or to define some things in or out as subject or not subject to allocation. It's sort of hard to see how the Commission doesn't have at least a little leeway there. But I just wanted to bring you back and see if I could get you to discuss a little more this question of for the purpose of influencing and what it means, for instance, vis-a-vis a proposal which would limit state parties who are conducting voter registration drives in years in which there isn't even a federal election.
Well, by federalizing and limiting activities such as party activities to get out the vote, to register voters, would seriously undermine the ability of parties to be a player in state and local elections. You know, the federal dollars, you know, they're only so much, and it can only go so far. And I mean, I served 5 years as the county chairman of my political party in my county where I live. And my view about parties is that they are a mediating influence, that they tend to moderate the voices that are involved, because their essential purpose is to gain broad support for their agenda, whether it be an issue agenda or an election agenda, so that they have a very salutary effect on the political process. Secondly, to talk about a political party corrupting its candidate is just absurd. I mean, where that does arise, I think, legitimately with, with other interests at certain levels of contribution. So you would think, and I think the quote in the Colorado Republican Party indicated that much of the intent of Congress was to strengthen political parties by, for instance, having a $20,000 contribution limit for hard money contributions as opposed to a $1,000 or $5,000 limit, and that the allowing also greater expenditures directly coordinated with candidates from parties. With their candidates was also an attempt to strengthen the role of parties, because I think they recognize they're inherently non-corrupting. And so that's why I'm puzzled by the policy approach that we should kneecap political parties by pretending that all they have to do with is federal elections, and thereby severely limiting their ability, as if they're just another PAC, in this whole process.
Let me jump in just briefly. First of all, would hope you would concede that there is no case, Supreme Court or otherwise, that has held a limit on contributions to a federal political committee to be unconstitutional.
No, and I don't know of any such cases yet been brought. But you're tempting me.
Congress.
There have been challenges to contribution limits to state political parties under state election laws. And in California, the entire Prop 208 was struck down. They didn't particularly deal with that subset of limits, the district court. And there's a case pending for decision in Colorado on that issue as well.
But as you were noting that the Common Cause folks and the Brennan Center folks haven't cited any of the cases that you found relevant in the way that you would like them to have, I just wanted to make it clear that from their perspective, they would say, well, you haven't cited any case that suggests that a restriction or limit on donations to party committees for the purposes of influencing federal elections would be unconstitutional. And
yeah,
that's because I don't think there are.
It's true to say that that there are no cases on that specific issue on either side.
The Supreme Court has upheld the existing federal contribution limits, at least some of them, the $1,000 limit on giving to candidates, the $25,000 annual limit that individuals have on how much they can give to federal candidates or political committees, and the $5,000 per year limit on how much can be given to a political committee. That was the CMA case.
Yeah, but they've never addressed the political contribution limits to political parties. Right. Or and in the case regarding contribution limits from parties to candidates in Colorado Republicans, they deferred to and sent that back.
But that's the outlay side. So, yeah. I'm talking about the money coming into the party committee.
Yes, they did not address the political party limits.
Okay, I will, at this point, in the interest of time, ask the council's office if they have any questions.
Just wanted to get.
I apologize. Excuse me, Commissioner Wald. I'm sorry.
I didn't jump in because I was going to say I don't have any further questions. I thank Mr. Bob for being here. I think his written presentation dealt with the issues that I was concerned with, and I don't have any questions to follow up on, so I didn't complain.
I apologize.
No harm, no fouls.
Are you yielding me your time?
At that point, if that were my alternative, I could quickly think of a question.
Larry Noble.
Well, after that, I'm kind of reluctant to ask a question, but what the heck. I know this was only on a motion for preliminary injunction. You dealt with the district court decision in the Republican National Committee, Ohio Democratic Party case. But just, I guess it was last week, the Court of Appeals denied a motion for preliminary injunction, and in that noted that it was an open question about the differences between political parties and other political committees.
Yeah, that in the record that they didn't feel, that they could decide that issue.
So you would acknowledge that, at least to that court, it's still an open issue about whether political parties can be treated differently than other committees?
Well, they refused to decide it. They didn't say it was open in the sense that your question may be interpreted. That is that there's an open question on whether or not you can impose limits constitutionally. They just said the record's not sufficient for us to decide that.
Well, actually, the actual statement was, without a clearer record, which is what you're referring to, as the differences and similarities between political parties and all other speakers in the political arena, it is impossible confidently to apply existing precedents, and this is the other part I would like you to comment on, themselves not free from possible conflict. Now, do you agree with the court there that the precedent being cited by both parties may very well be in conflict on these issues?
No, I don't.
You think there is no conflict?
No, I don't think there's any conflict on the question of whether or not issue advocacy can be regulated by any speakers, by any speaker. I don't think there's any question that issue advocacy may not be regulated, no matter who the speaker is.
Can we agree that the question of jurisdiction is going to come down to whether or not, or what standard is going to be used to decide whether something is for the purpose of influencing election under FEC? And that
in part, yes.
And if the courts ultimately decide something is for the purpose of influencing, the FEC will have jurisdiction over that.
If under a constitutionally acceptable definition of what is influencing, yes, and if it's influencing a federal election,
yes, federal election.
There'd be two parts to it. There'd be two parts.
So there would be no debate there that the FEC has jurisdiction over those type of expenditures or contributions.
I think that's true. If it's a federal election and if the activity is constitutionally encompassed properly within influence, and I would say it's a narrow construction of express advocacy, then yes, express advocacy of activity of a political party is subject to the FECA.
Does your narrow definition applying express advocacy also apply to the definition of contributions?
No.
So you acknowledge that in the contribution field we have a broader jurisdiction?
No, no. There's no an expenditure for a communication. You have to look and see if it contains express advocacy. If you're making a contribution for an expenditure, for a communication that encompasses express advocacy, the contribution would be subject to the FECA as well. So for instance, you could require, as the FECA does, you to report any contributions you've received to engage in that independent expenditure, for instance.
So you believe the contribution limits do not apply to contributions to a political party that would be used for overhead electricity to buy supplies?
If it's not, for the purpose of influencing a federal election, properly defined, then it's outside your jurisdiction, whether you call it a contribution to the party or you call it an expenditure by the party.
So in that
the same phrase is used in both definitions.
So in that sense, you do disagree with the CMA court? Where the CMA court said that administrative expenses, paying for administrative expenses of a political committee is still a contribution to a political committee.
If the administrative expenses are used to support expressly advocating the election or defeat of a federal candidate, then that is subject to the Act. I would agree that's subject to the Act, that administrative expenditure. But it has to be related to something that is for the purpose of influencing a federal election.
But it doesn't have to be a direct relationship. We don't have to show that the administrative expenditure or the contribution went to an administrative expenditure that went directly to typing up an ad that was expressly advocated.
No, and it's really kind of ironic because I'm agreeing with you, but by saying that your current regulations are upside down, because your current regulations don't allocate, well, they allocate administrative expenses and then they allocate issue advocacy and get out the vote. The part that I would agree to is the allocation, that you would have the authority to require allocation of administrative expenses used to support express advocacy or used to support candidates given to federal candidates. I would agree you could do that. Now as to, that would disadvantage parties vis-a-vis separate segregated funds where the corporation can use 100% soft money to pay the administrative expenses of a connected PAC, you may, as a policy decision, not want to disadvantage parties relative to other players. But from a statutory interpretation standpoint, I think, yes, you could require allocation of administrative expenses that are used to support the hard money activities of the party.
Thank you.
Yes.
Thank you very much. I would hope we could, oops, Commissioner McDonald, I was just hoping we could move on to the next witness, but
I just want to make one comment because maybe I misunderstood Jim. Thank you, Mr. Chairman. I'll be very quick. One of the things that I thought you said, and if you did, I want to disabuse you of it, at least from my standpoint, is I'm not of the opinion that the parties corrupt the candidates, and I thought you said that, and maybe I misunderstood you. That really is not what I think this is about, and I certainly don't think the parties corrupt the candidates.
Well,
did you say that, or did I just misunderstand you?
No, I said that, and some people have argued
that would be
it.
wrong in my case.
Yes, okay. And so, but some people, I was addressing not necessarily what your opinion is, but what some people have argued is that the contributions to parties corrupt their candidates, and I don't see that.
Thank you.
let us proceed to our next witness, if we may. We're still running about 25 minutes behind schedule. I understand that one of my colleagues is obligated to go to a crucial parent-teacher conference, and so I'm hopeful that we can...
But I'll be back.
That would not be you.
Oh, it's not me.
So I'm hopeful we can move expeditiously in the opening statements, Paul, and we can allow that commissioner perchance an opportunity to actually get in questioning. We have before us Paul Sullivan. Help me, I'm fumbling away
and,
here.
Commissioner Thomas, I'd like, with your permission, to have Cleta Mitchell join me this morning.
Thank you. I apologize, Ms. Mitchell.
Chairman and General Counsel of
before.
Americans Back in Charge.
Former pride of the Oklahoma legislature, I want to point out as well.
I beg your pardon. I was... I didn't have the right piece of paper in front of me, but both of you are quite welcome. Please proceed.
Thank you, Mr. Chairman. And I will try and speak quickly because I had to go to a parent-teacher conference this morning myself. So,
I knew I should have had kids.
Acting Chairman Thomas and Commissioners, on behalf of the First Amendment Project of Americans Back in Charge, it is my pleasure to have the opportunity to appear before you this afternoon and provide comments regarding the Commission's proposed soft money regulations. The issues encompassed in these proposed regulations give rise not only to some of the more controversial campaign finance issues of the past several federal election cycles, but more importantly, they go to the very heart of the relationship between the First Amendment and the government's authority to regulate First Amendment rights. In addition, these proposed regulations directly impact the 10th Amendment's principles of federalism in the area of election law. As a preface to my substantive comments pertaining to the proposed regulations, permit me to briefly describe to you the First Amendment's project's interest in these proposed regulations. We live in an era when most campaign finance, quote, reform, unquote, efforts equate to greater regulation at the federal and state levels of political speech and activity. In fact, under the banner of campaign finance reform, some have even called for amending the First Amendment. In 1997, Americans Back in Charge Foundation established the First Amendment Project to provide research, public testimony, and publications in opposition to the conventional approach to limiting political speech under the guise of campaign finance reform. The First Amendment Project is dedicated to the principle of full disclosure of campaign contributions and expenditures, but much less regulation of political speech. It is our belief that this principle is guaranteed by the First Amendment, as I'm sure the Commission would agree, as applied by the Supreme Court in cases beginning with Buckley and proceedings since then, and numerous subsequent decisions of the federal courts across the country during the past 20 years. We applaud those decisions and oppose the efforts of many today who would sacrifice these basic First Amendment rights to ill-conceived and misguided campaign finance reform proposals. The First Amendment Project exists to support and advance philosophies and policies which permit the American people
to engage in the unlimited exchange of political ideas, issues, and viewpoints. Second, to support candidates and committees of their choice with only very limited regulation. Third, to require the prompt disclosure of contributions and expenditures. Fourth, to protect the right of each state to enact and enforce its own system of elections and campaign finance regulation within fundamental constitutional parameters. In that regard, the First Amendment project appreciates the opportunity to submit this testimony to the Commission today. Regarding the proposed regulations, I will summarize for you our comments which were previously submitted to the Commission in full text. I will attempt to be brief with these remarks, anticipating that our position will be explained in greater detail during the question and answer portion of the testimony. Several persons responding to the Commission's earlier notice of availability raised questions regarding the Commission's jurisdiction and the very authority to regulate the so-called soft money. Such objections appear to us to be the threshold question that the Commission must, and I believe has recognized, to be resolved before the Commission can proceed with this subject matter. We believe that the jurisdictional objections have merit, and that the Commission, with all due respect, has no statutory or constitutional authority to promulgate the proposed regulations. Those in Congress and the administration who urge the Commission to adopt these regulations do so in large part because of their inability successfully to enact the statutory changes that they are promoting, and because their position has been rejected repeatedly by the federal court decisions, which continue to limit the stretch and the reach of the FECA on constitutional grounds. Further, the Commission's jurisdiction in this area is tenuous in light of the definition which the Commission itself has established for soft money. Specifically, soft money is defined by the Commission as those funds used to pay for activities which do not influence federal elections. Thus, it is our position that the Commission, by its own definition of soft money, lacks subject matter jurisdiction to promulgate the rules and the regulations in this area. Those who advocate these proposed new regulations appear to assert that there are activities presently being paid for by soft money to influence federal elections. If that is the Commission's belief, the obvious solution to that problem, and I believe you've heard this before, I'm not the first, is to greatly expand the regulatory framework, is not to expand the regulatory framework, but rather for the Commission to enforce the existing law which already prohibits the use of soft money to influence federal elections. Further, we would submit that the way in which this question has been framed through these proposed regulations is somewhat confusing and only adds to the misunderstanding of the issue by the public and especially by the press. Further, we would submit that the way in which these soft money is already prohibited from being used to influence federal elections. These proposed new regulations have been described publicly as a way to stop soft money from being used in the future to influence federal elections. This is a circular and wholly misleading argument, in our opinion. A misplaced belief that activities which are already illegal is not a sufficient justification for the Commission to assume authority not authorized by Congress to promulgate these proposed regulations. The proposed regulations are far more reaching than simply, quote, reforming the use of soft money. We turn our attention, therefore, to the specific proposed options proposed by the Commission. As noted in our written testimony, the First Amendment project strongly opposes the second option of the rulemaking proposal, regardless of the three variations proposed under that core option. There, in our opinion, does not appear to be justification through any of the testimony or evidence presented to the Commission that all national party activities and all state party activities are undertaken for the purpose of influencing federal elections. There is simply no evidence to support that conclusion. The third variation of this second option is especially offensive to the principle of federalism, in our opinion, and our belief that the states and the state parties should not be subject to total federal intrusion and control by the system by which state parties undertake to support the elections of their nominees and governing officials. In addition, the Commission has not received evidence to our knowledge to demonstrate that there are in fact activities covered by the FECA which are being paid for by soft money. If such evidence is received, presumably the Commission would act to enforce existing laws against such expenditures. The mere fact that there has been an increase in the amount of money spent by state and national parties does not equate to a finding that would justify the proposed increased scope of the Commission's regulation. The party committees, for example, are still subject to the allocation formulas presently contained in the regulations, whether it's the 60 or 65% for administrative, GOTV, and registration drives. The percentage of federally related activity cannot be assumed simply because of an increase in the gross dollars spent by the political parties. There is no definitive correlation between the two. In addition to these primary issues, there are several collateral issues which we believe require the Commission's attention. First, the determination of what party activities are deemed to be for influencing federal elections will many times turn on the content of the message delivered. This inevitably brings us back to the boundaries imposed by the Supreme Court in Buckley and subsequent cases, requiring the expressed advocacy language before communication can be subject to the FEC type regulation. This all relates, of course, to the now infamous issue advocacy and grassroots lobbying activity, which simply is constitutionally beyond the regulatory authority of the Commission. The Commission, like it or not, must be mindful of its constitutional limitations at the same time that it considers the party committee soft money issues. The largest outcry during the 1996 election cycle relative to soft money was not the payment for registration or get-out-the-vote activities, but rather activities involving issue advocacy type communications. Second, we would propose that the Commission review the option of having no allocation requirements for national or state party activities for generic voter registration or get-out-the-vote activities. Recognizing that the only justification to date recognized by the courts to limit contributions and especially expenditures is corruption and the appearance of corruption, we would submit to the Commission that we would submit such party-sponsored registration and get-out-the-vote efforts do not lend themselves to such potential corruption elements. The courts also appear to be acknowledging this principle, as the Supreme Court concluded in Colorado Republican Federal Campaign Committee v. FEC. We should be looking for ways to loosen the restriction on voter mobilization, not increasing them in order to encourage greater participation in the election process by our citizens. The decline in voter turnout is an ongoing issue, and the Commission, we would request, should be conscious of the impact on turnout of any proposed regulation of these essential voter registration and get-out-the-vote activities performed by the state and local parties. Thank you for this time to present our views, and I would certainly welcome questions. Thank you.
I have no comments beyond the ones presented by Mr. Sullivan.
Thank you. Commissioner Sandstrom.
Yes, I'm the one who's going to have to speed off to the parent-teacher conference here, so my questioning will be short. First, I would note for a commission that's split, even number of members that sometimes ends up 3-3. I'm glad there's someone's out there trying to seek to put someone back in charge.
Glad to do that if you'd like for us to.
We'll consider that. But we didn't see that as part of your written proposal, so we'll have to leave that for another day. With respect to issue advocacy, which some suggest is completely outside of our jurisdiction, even if undertaken by a political party or a political committee, does that extend to even the receipt of foreign contributions?
To fund issue advocacy?
Issue advocacy.
I think it presents an interesting issue in that if you take a look at 501c4, C6 organizations, which oftentimes are the sponsor of such issue advocacy, the IRS does not specifically prohibit the receipt of such funds. And I think that that is something that the Commission should similarly consider when taking a look at the issue advocacy, is not to take a look at it in the vacuum of just the political parties, but take a look at it in the entire context of other organizations that are going to be undertaking issue advocacy. Obviously, there are groups out there that perhaps would set up such C4 or C6 organizations. In fact, if such regulations restricting issue advocacy were promulgated. So I think that the Commission needs to take a look at this in the larger scope and not limit that specifically to the political parties. And in that context, Commissioner, I think that that remains an open issue.
Being an open issue, and it does concern me.
I think it would concern us also. I believe that it remains an open issue. I don't think that there's been a conclusion to it.
I'm not even sure we'll be back in charge of our elections if we don't extend the jurisdiction and read our jurisdiction at least that far. But I want to thank the panel, and I'm going to have to duck out here. Thank you.
Mr. Sandstrom, as you go out the door, but just remember that Congress has already banned foreign contributions to political campaigns, and Congress has the authority to change the IRS code to ban foreign contributions to such 501c6, 501c4 organizations.
Thank you.
Commissioner Wald.
I just want to go back to a statement that you went through pretty quickly in the earlier part of your remarks, Mr. Sullivan, that I'm not sure I fully understood what you're referring to. You were talking about the definition in the Act of for the purpose of influencing any election, and seemed to indicate that there might be some flexibility in that definition in determining what does influence a federal election. That were you inferring that we have some room for flexibility there, that we could define further what is for the purpose of influencing a federal election, and thereby deal with some of the some other advertising out there that has been defended as being just issue advertising and not specifically advocating the election or defeat of a candidate?
Commissioner Wall, I think as you go down the continuum, if you do say that there is flexibility, you inevitably get back to an assessment of what is the content of a message, for example, contained in issue advocacy. And I think, you know, we've heard from previous panels about Buckley, and I think it's been cited too in subsequent cases. The need for this expressed advocacy standard is not just the words of having vote for or against or whatever. It is to address the issue of vagueness. And without the expressed words contained in, or the expressed advocacy standard, you get into such a gray area of what is to influence and what is not to influence elections that the courts, and we strongly concur, have stated that we are going to state that it has to be an expressed advocacy standard or something very comparable to it. And we may err on the fact and the recognition that some of these activities may in fact, quote unquote, influence an election. If a candidate for Congress is arrested 2 weeks before an election, clearly that has an impact and influences the election. Those are types of activities that clearly go beyond, I think, the concentric circles of authority of the Commission. So in the view that, yes, there is a broad definition, I think, that could be attributed to for purposes of influencing, I think the courts have come to the realization that without those type of expressed advocacy terms in issue advocacy, for example, you're second-guessing the purpose of the activity, whether it's to lobby a member of Congress through grassroots lobbying a month or so before an election, when we know that's when most of the legislation is at the critical stage, some of the more important issues. And who is going to make that call? And I think that's why we concur there has to be these terms of expressed advocacy.
It seems to me that the phrase "for the purpose of influencing any election" doesn't really help us much in determining what kind of advocacy is subject to the provisions of the Act in terms of requiring that it be engaged in only by through the use of hard money, because it virtually, as you point out, virtually anything could be could influence an election. But I'm wondering if it's something just more than if the express advocacy standard enunciated by the court in Buckley has any room for adjustment itself. If the only purpose of that standard is to provide some certainty and avoid vagueness, could we come up with some other definitive definition that would avoid vagueness and thereby satisfy the constitutional concerns with the standard?
I would think that if the past 25 years or so gives us a lesson, I don't think that you're going to see that type of option coming forward that gives the clarity, the bright line, as it were, between classic grassroots lobbying of issues and legitimate attempts to influence candidates in federal elections. And I think just by default, that is the area that the Commission is limited to as far as its jurisdiction.
Thank you.
Yeah, if I might add one comment that goes back to a question I think Commissioner McDonald asked of the previous witness, and that is the court did uphold the contribution limits in Buckley. But it seems to me that a fair reading of that is that that one of the primary reasons that the court upheld the contribution limits was because, as the court stated, there would be other avenues by which individuals, participants in the political process, could make their views known on issues and ideas and political activities. And that short of that, there's a question in my mind as to whether they would even have upheld the contribution limits at all. And so much of the discussion about soft money ends up revolving around a notion that somehow this is an unintended consequence of the act or the court's decision in Buckley. And I would take quite a different view, which was that the court quite clearly anticipated and commented on the fact that people would find other ways to make their views known, and anticipated that and said the First Amendment guarantees that whether we like it or not. So I think the court has defined for the purposes of influence in election. I think there's been a 20-plus year effort, which is ongoing, to try to find a way to unwind the court's decision, but thank God for the First Amendment that protects us from those efforts.
Thank you.
Commissioner McDonald.
Mr. Chairman, thank you. Paul, Cleta, it's good to see you. There's a pattern developing here. Second executive assistant that used to work with Commissioner Elliott. She's very obviously proud. Made some very good choices. She can be very proud. They went on to make money, and we just went on. And in the interest of full disclosure, of course, I would tell folks that I did give Cleta Deathridge money when she was in the House of Representatives in Oklahoma. I think she'll acknowledge that, and I was certainly glad I did.
And I didn't feel the least bit corrupted by it, Commissioner.
Well, not with the kind of money I was able to get. I can sure see that. That would be true, Cleta. That would be true. Welcome. A couple of things. Jim just wore me down, so I'm getting tired at this juncture. But there's a couple of things. There's a couple of things that I have an interest in. I might start with the last comment that Cleta made. It's interesting to me. One of the great mistakes that I've made since I've been in this town, I made as many I've lost track, but the one that I can think of right off the hand was I had the great fortune years ago to have lunch with Senator Hugh Scott and Senator Church, and it was quite a long lunch, I'm proud to say. And I always felt bad that I didn't record the luncheon, because clearly it would be interesting for them to hear this discussion, because they didn't get what we've been hearing today out of Buckley versus Vallejo. And by the way, that might not be right. Everybody's entitled to their own interpretations. But it was interesting because they were there at the outset of the process. I think another view, Cleta, might be that it never dawned on the court that only money was the way to express your views. I mean, maybe in the readings that I have of Buckley, and we all read Buckley the way we want to, I don't know. My mother's in Sand Springs, Oklahoma.
My mom's in Oklahoma City.
Yeah, well, there you go, urban versus rural. The problem is this all escapes her in terms of the kind of money. She can participate in one of several ways. She doesn't join a political action committee, although I suppose she could. I think I would submit to you, just for thought more than anything else, I think the court didn't think just in terms of money. I think I'm interested. Every year we have a recorded expenditure. Every year. No one doubts that. You can look at it every quarter if you want to. And yet the turnout of vote, which is a real concern, doesn't seem to be working. I mean, I don't I don't see the cause and effect relationship. If the suggestion is that more money helps the turnout, I would submit to you you're going to have to prove it to me, because that's not what has happened. I don't think at any time do I see that being the case, and I know this has been alluded to as well. And Paul was talking about we need to be worried because of the decline of voter turnout. But Paul, how do you explain as the money goes up, the turnout goes down?
I don't think that's the relevant portion of the issue, Commissioner.
Well, you brought it up. That's the reason I asked you. You may have brought up irrelevant stuff, but I think everything you say is relevant.
It certainly won't be the first time, based on some of the comments. But the question once again gets to the Commission's jurisdiction, and I think that is what the heart of these hearings are, as far as the Commission is concerned.
I agree with that.
And the idea of coming through and telling the political parties, especially at the state level, whether it turns out the vote or the registration with larger amount of monies, I don't think is our specific concern. I think the concern of the Commission is whether or not you have the authority to restrict the source of funds used at the national and especially at the state level for such activities as registration and get out the vote. Now, if in fact there is a restriction, such as being proposed by the second option here, to require that state parties use all federal money, then I would submit to you, Commissioner, then yes. I mean, some of that money is going to be used by the state parties for issue ads, for support of candidates, rather than registration, GOTV type of efforts. Second of all, I think along that same line, and it's a point I think we made in our written testimony, is you take a look again at the nonprofit organizations that are able to use their corporate money to do this at the national level. You take a look at 27 states that permit corporate contributions directly to be contributed to candidates, let alone for registration to get out the vote. And again, I would submit to you that in those 27 states, one being my residence now, Virginia, and my former residence in California, I have not yet seen any empirical evidence, studies, whatever, that California or Virginia or Illinois are more corrupt than the federal system or Massachusetts that may have the most restrictive regulations in the country. There's just does not appear to us to be that corollary. And absent evidence of such a corrupting influence, our point is that the Commission should defer until that evidence is submitted and permit the state parties and the national parties to spend the money from whatever source they see, whether it's corporate or individual.
Well, it is why I asked Common Cause that question this morning. You would take, obviously, a totally different point of view than the witnesses coming on this afternoon in relationship to what our authority is, the members of Congress. You've no doubt read their comments.
I have, Commissioner.
And you disagree with those?
Most of it I do, yes.
And you disagree with the bulk of Congress. We all understand the filibuster activity, but you disagree with the bulk of Congress, both in the House and Senate, say that there ought to be a ban on soft money.
Here is my concern about it, is that you have got a regulation at the federal level that prohibits quote-unquote soft money. What is the impact on the states? And I think that has been a subject that has been not adequately addressed in most of the testimony. We tend to focus just on one campaign finance system, that being the federal, without focusing on the balance of the 50 states that have their own campaign finance structures. And viewing it in that vacuum, you are not going to be able to prohibit the use of soft money. We could go to the state of Illinois, California, whatever state party, and cut the same television commercial, have it run through the state party. Rather than have contributors contribute to the national party, they contribute to the state party.
What's wrong with that, by the way? Why don't we do that?
I think that it can certainly...
Because that really does get back to the states then. If we just take your position, which I think is very intriguing, why don't we do exactly that? Why don't we say, look, this is a state's matter. Let's don't have the parties get involved in this at all at the federal level. Let's make it truly a state matter, and the 50 state laws would apply, which, as I understand, that's what you're really advocating. So why don't we just do that?
That is not specifically what I'm advocating as far as restricting it at the national level.
Why don't we do that? I'm advocating it then. Why don't we do it?
Because I don't think that there is any jurisdiction for the federal government to come in the area of issue advocacy, absent the expressed advocacy, to prohibit that type of activity. Again, I think we have to operate from the perspective that all speech is permitted under the First Amendment. And I know we keep getting that, it's almost gotten cliche-ish, but I think we have to get back to a value of that. And that what we're required to do is just chip away at that First Amendment right where there is a compelling government interest to restrict that speech, and in a narrow context. But the example you just used, yes, I would submit that the state should have that, and so should the national parties, simply because it is not restricted. We don't have to get to the point where it's permitted. We merely have to show that it's not restricted.
Well, I'll close, Paul. I appreciate the dialogue. I would only say to you that in relationship to one of the things that has constantly been left out, and it started with the testimony this morning, we're not interested in $39 and $50 contributors. It was written in the testimony. Everyone knows that. I think you would have to be deaf, dumb, and blind to think that anybody at the commission thinks that. It's certainly not your position, but that was taken early this morning. And the issue is about free speech, and it is also, which seems to be left out at least of the presenters this morning, but it also is this business about power and money. And money is important in politics. It truly is the mother's milk of politics. Nothing wrong with that. But I want to be sure that we focus on the other side of the equation. The other side of the equation, you being from California, as Jim pointed out, the citizens actually out there, overthrown, by the way, by the courts, they wanted to take a position because apparently they were concerned about it. And there we took the position, well, they weren't actually right. So that was appealed, maybe appealed again, who knows the answer to that. Same way with term limits. You know, I mean, that's an interesting infringement on my ability to run for office. So I guess what I'm saying to you is that it is a balance, and that's why I always like to hearken back to Buckley versus Vallejo myself, because it is a balance, and it is not just about chipping away at the First Amendment. I would submit to you that there's more than just chipping away at the First Amendment, and that's the kind of thing that we're going to have to reconcile. Thank you. It's good to see both of you.
Commissioner Mason?
Thanks. Some of my colleagues played devil's advocate this morning, so let me do it now, because Paul, you've crystallized for me something that bothers me a little bit about the situation we sometimes find ourselves in. And we start off by saying that I'm very sympathetic to the argument about the necessity for a bright line test, and I understand why that's been applied. But by pushing the application of that as far as you have, I think is the way you've crystallized it, and that is you say, well, under that test, we couldn't even or shouldn't even require allocation of generic expenses by political parties, that is voter registration, get out the vote, and so on. I'll even leave aside what I think is a more difficult question about candidate-specific advertising by parties. And the problem, it seems to me, is that on the one side you have people who say, well, gee, we want to regulate everything a political party does as if it were a campaign expense on a federal campaign, when it's fairly obvious that political parties do a lot of other things. But if we say that the Commission can only regulate express advocacy, and that's it, we end up in a place that you've presented, at least by way of argument. I don't know if you really think we ought to go there or not, which is to say that that nothing a political party does except express advocacy is subject to regulation. And it seems to me that one of the things that's clear is that the court did leave room for a different category vis-a-vis political committees. And political parties, of course, are one category of political committees. Just by further way of background, we all know that not everything that a political campaign does is express advocacy. I think in the last election, Senator-elect Schumer's catchphrase was too many lies for too long. And he didn't feel like he had to say vote for, defeat, or anything else. That got his message across sufficiently. So if we're allowed to regulate political committees in some fashion or other, why aren't we allowed to do something something beyond express advocacy?
Commissioner, I appreciate the logical conclusion that you could take the argument to. The concern that I think we have is the reach of the commission into the states, the state party and the state committees, notwithstanding the fact that they are there to get out the vote or conduct registration or polling or whatever. The idea that the FECA could be used to regulate some of the administrative cost, which I believe is where you're going with the question, that are not per se expressed advocacy. I think the expressed advocacy does apply in the area of issue communication or communications, radio, print, TV. When you're getting to the issue of support activities, staff, polling services, the typical type of thing that you'd run into at the national committees, yes, I think there's an argument there for some allocation, because those are support services that do support the expressed advocacy. And I think Jim Bopp on the previous panel agreed with that. How you get to that allocation and the justification for it, I think, is the gray area right now, and it always has been. The idea, however, of stating that all of that activity at the national and the state level is for federal activity, I think goes too far down the continuum. There has to be a recognition somewhere in the middle there. One of the proposals you could take a look at is to take a look at how much money does the national parties spend on direct contributions, coordinated contributions, independent expenditures, and use that against the total gross dollars raised during that election cycle and come up with a percentage. Another allocation possibility in the area of states and the get out the vote and registration that Commissioner McDonald was talking about is in fact using what I think is a more reasonable system, the allocation system you have in place right now for the state parties. That is the ballot composition formula. In other words, that ties, I think, more directly to the impact of a registration or get out the vote drive, and perhaps the same is applicable for the staffing. But I think it does need to have as a basis what are the amount of dollars that are actually being spent to directly influence a federal election versus money that's being used to support governors or state and local candidates, et cetera.
If I might add to that, philosophically, your question is, what is the reason? Why shouldn't the commission be able to do more, essentially? And I come back to what is the compelling governmental interest in the regulation at all? And the Buckley Court said corruption or the appearance of corruption. And I think that the court has clearly said that political parties can't corrupt their candidates, and political candidates can't be corrupted by their parties. And beyond that, so it is that standard. That is the reason. And I think that is the test that the commission ought to apply to any one of these proposed regulatory frameworks. What is this doing something to avoid corruption? Now, there have been a lot of assertions that somehow people raising money, just the mere fact that there are fundraisers and people, is it 601 transactions and $79 million? Is that what it is that you keep referring to, Commissioner?
That'll be a lot fewer groups, yeah.
But so what? I mean, what? Tell me.
Can I answer that?
Yeah, well, no, let me finish and then tell me more.
Well, tell me when you want me to answer.
But the fact of the matter is,
He's a good guy.
unless there is evidence of a corrupting activity, there is an inference that the money in and of itself is corrupt. And I think that's the question the Commission has to ask. If there are those people who believe that all private money in politics is inherently evil and corrupt, the Supreme Court of the United States has rejected that notion. Thank goodness, for those of us who don't agree with that. And so then you start down the line of how much is too much? And who's going to be the national Goldilocks to say, you know, this one's too much, this one's not enough? That's the problem. And I think that the bright line tests are very important, the corruption reason and the express advocacy standard, because otherwise we can never enact a framework that would meet constitutional guidelines.
I want to hear these instances of corruption.
No, I won't take up my colleagues' time, but I'll plead at the lunch. No, it's interesting because it really didn't answer the question. I mean, it's interesting, but actually there's a lot lower threshold. I mean, what's so fascinating about the argument is that under federal law, the guidelines are much lower for individuals, corporations, labor unions, which obviously are in a totally different ballpark altogether. They have a much less flexibility under federal law. So at the federal level, that has been established, by the way, and it turns out the Goldilocks is us as luck would have it, good or bad, and I can tell that it meets with marginal approval, usually bad. But it is interesting because the reason that's significant, Cleta, and you know this as well as anybody, I believe you used that up appropriations.
I did.
I'll guarantee you I know who gave you money, and there wasn't anything wrong with that. But the point was, if you say under the law, under the federal law at least, that determination has been made, and it has been made. One of the things that Craig did this morning on his chart, that looked like those kind of charts we used to testify to over on the Hill. The fact of the matter is that ironically, they not only made that decision, but they did cap it. I think they made a mistake, by the way. I happen to agree with Craig about that issue, which made the money even less as we went along in time. So the relevance to all this, quite frankly, is the unbelievable disproportionate amount of money that can go from individuals through this process. That's the issue.
Well, the real issue, frankly, is that as long as we have a government that reaches every aspect of our lives, it should not be surprising that people who are subject to it, either in their individual lives or their business and industry, where their very livelihood depends upon government regulation, it should not surprise any of us that they will spend a portion of their dollar to try to influence the outcomes that affect their lives. I mean, that's the issue. And all of this whole discussion is really quite ancillary to the ultimate issue that if you really want to address corruption, so-called perceived corruption in lobbying, et cetera, do something about the tax code. I mean, those are a lot of fundamental issues, and we're over here
we just don't have any say over that, but I appreciate you giving it to
But don't try to fix those problems through some ill-conceived regulations of this agency. That's what we're saying.
No, I agree with you, but we'll have this discussion at lunch.
Commissioner Mason, any more?
I don't want to start anything else.
You do. I know you.
Let me sort of try to put this in focus. I mean, let's say we have this ad. It says, only Republicans can save Social Security. Support the Republican approach. And let's suppose that, we'll start with the National Party committees. Let's say one of the National Party committees wants to pay $5. Suppose, I think you're most closely associated with Mr. Forbes. Let's assume Mr. Forbes is going to be the Republican nominee in 2000. And let's suppose that Mr. Forbes is going to be sending out the solicitation letters for the party, asking that donations be contributed so the party can run these kinds of ads. Under the allocation formula, let's say that it's roughly $2 million could be raised in soft money to pay for the soft money non-federal share, and the remaining $3 million could come out of hard money. Now, let's set that as the background. Are you saying, first of all, that your preferred approach would be that the Commission shouldn't even require any hard money to be utilized to pay for this kind of an ad, that because this falls short of express advocacy, you would prefer that Mr. Forbes could raise entirely soft money chunks to pay for this kind of communication during that general election phase?
I would say yes.
The answer is yes. I've got the reason I hesitated, Commissioner, is that I think there's a fundamental issue that you just referenced here, and that was the two, $3 million in hard dollars and $2 million from soft dollars, or vice versa. I'm trying to determine the logic, as it were, of where those allocation formulas are justified. And I think it gets back to a point that Commissioner Mason raised earlier. But as you go down that continuum, I think you get to the point, and I think the courts have recognized it, I think it's been the problem, and I think the Commission has been in the middle of it, but the reality is, who is going to make that judgment as to what is the intent of that message coming out? If that message, for example, if I could go a little bit further with it, and one that typically comes up, and I'll use Senator Fairclough, during the last session of Congress, where the last month, 6 weeks, there are bills that are pending in the Senate. You want an association to go out with a grassroots message. Call Senator Fairclough. Tell him you either support or oppose this piece of legislation. He is in the middle of a knockdown, drag-out re-election battle. Your argument clearly is that message, if it's broadcast statewide, is going to have an influence on his election. Possibly. Probably. The question is, what is the intent? Is it going to be regulated by the government when, in fact, the people paying for it, the ABC Association, has a legitimate grassroots lobbying business interest, as it were, in seeing that Senator Fairclough either change his vote or, remain tough in opposition? That's a classic case where you've got that statewide candidate. Those are the type of issues I think that you get into with the soft dollars, and trying to make that determination, whether it's case by case, is difficult. And I think that's why you're left, albeit perhaps not satisfactory to most people, with the idea that there has to be a specific, clear-cut intent to influence the election of a particular candidate. And absent that, and as the courts have recognized, you default back to, well, we're not going to get involved in that area. The presumption of innocence, as it were, has to go to, and should go to, the people that are sponsoring the communication.
Well, I don't recall if you were here at the very outset. With regard to party committees, I took the first panel through the exercise of noting that they are telling the Internal Revenue Code that they qualify as a 527 political organization, and the very definition of such is that it is primarily for the purpose of electing candidates or selecting candidates. So you start with the premise, it seems to me, that a political committee under those circumstances is primarily undertaking its efforts for the purpose of influencing elections. The example you gave was different. You gave the example of an interest group of some sort that I gather would not be a political party. It seems to me that where you've got a party organization, which for the most part is set up to influence elections, and where you have quite commonly the very same people who are running for office very intimately involved with the decisions about what activities the party undertakes, the connection between the money coming in from donors to fund the party and our federal candidates is so much closer that in the logic of the court, a contribution restriction is totally justified, because there you have certainly the potential for corruption. You certainly have, in the view of most people, I would think, the appearance of corruption if you let a huge unrestricted donation come in to pay for that kind of activity. People cannot give money to the candidate in the general election because ordinarily they're publicly funded. Now, Mr. Forbes may not opt for that approach. but typically they cannot give very much to the candidate. But if they can give an unlimited amount of money from a corporate source or a union source, it seems to me that you would have to concede there is more of an appearance of corruption.
Commissioner, I think you, and I'll try and address some of them, and I think Cleta wanted to also, but I think you just articulated one of the major concerns that the courts have had, and I think we have in dealing with this entire issue of what is, for purposes of influencing the candidacy of a federal candidate versus state, and who is paying for it. In other words, if you took that same message that you just held up and had that paid for by a trade association or a non-for-profit organization, issue advocacy type of group, would the standard of review be the same for that organization, or would you have a different standard for a political committee? What if it was paid for by the national committee versus the state party in Illinois or California? Is there a presumption there that their primary influence or attempt to influence is the state candidates and ballot composition, et cetera? And I think that trying to capsulate this into one set of regulations very narrowly to cover all of those different situations, I think capsulizes the difficulty of the issue.
If I just might add, you know, the example that you just held up is, I believe, a perfectly appropriate use of party dollars, contributions to political parties. And think about what we all hear about. They will start, the media will begin sometime in mid-1999, if not sooner, talking about generic ballots on issues like Social Security, like Medicaid and Medicare, like education. And if you care about these issues, which party's candidates are you most likely to support? So that it is a perfectly appropriate activity for political parties whose ultimate goal ultimately is to elect. They keep score by how many of their guys win, which is not inappropriate. But it is appropriate for what we call political climate control. And we've seen that in the last two cycles. And while there are those who oppose it, and I may disagree with some of the people who've been heavily engaged philosophically, I might disagree with them. I believe they have the right, the unions had the right to try to change the subject in 1995 and 96, and they successfully did that. And they have been actively involved in climate control. The political parties have an interest in the political climate on these issues. Now, maybe that does ultimately influence the outcome of an election, and the Supreme Court, again, in Buckley, said that you cannot, these issues and candidates are inextricably intertwined. But knowing that, I mean, I just have a hard time seeing, with that example you just held up, if I thought the Republicans had an approach to saving Social Security, I would like to hear it. And, you know, I'm looking at your example and thinking, what is corrupting about that? What is there about an ad like that that is corrupting? And so that may be too simplistic a view, but I'm new at this regulatory body, et cetera. I've just been in politics and law my whole life, and I just look at it and say, keep it simple. And if it's not corrupting, and if it isn't an express advocacy standard, if it doesn't meet that standard, leave it alone.
Well, I've been trying to get us to focus on the process of gathering the money to do that. That seems to me to be the focus of the inquiry, not so much whether the parties ultimately put the money out for issue ads. The focus is on the raising of the money. That's where the danger arises, as I see it.
Commissioner, could I address that, because I think it was part of your question earlier, and it's been a question to the panel earlier today. The question of the solicitation of the money and into what account it goes, I think is responsive to your inquiry, and it does tie to the purpose of the expenditure, or what the money is expended on. If you are expending the money to make a contribution directly to a candidate, 441 AD, or an independent expenditure, then clearly that has to come out of the federal committee. If the money is solicited for that purpose, then it's subject to the FEC regulations and the limits. If it is solicited for purposes other than that, whether it's the Governor's Association, the state and local, the building fund, administrative issue advocacy, whatever, then I think those are the laws that dictate what are the contribution limits for the money coming in. You take a look at what are those funds going to be used for on the expenditure side. It's similar to setting up a non-connected committee, and you've got your federal account and you've got a state account. Right now under the system, it depends on what you're going to be expending those monies for will dictate what permissible sources may be used to receive the money coming in.
Okay, thank you. Commissioner Elliott?
Thank you. I was delighted to hear you say that you did not believe registering to vote and getting out the vote were corrupting influences. You were not here for the some of the early part of it, but here's what I see as a dichotomy. Corporations can contribute to the League of Women Voters for their get out the vote and registration activity and get a tax deduction for it. They can do that to all the ethnic registration groups that are going on of all different kinds all over the country. And every minority that you can think of has one, and they get a tax deduction for it. Yet, if they give it to a political party for get out the vote campaign, we say, aha, you can't use any of that, or maybe in some places just a portion of it, because it has a federal implication, and so you cannot spend all the money for that. You have to allocate it between the hard and the soft dollar account. Now that makes no sense whatsoever, and I would think that if the Congress gets to the point where they make all of this hard dollars, that the League will have to have only hard dollars under our rules. All the think tanks that present issues will have to be under some kind of an allocation rule also. It just doesn't make sense that there is something corrupting, some reason for a control of registration and get out the vote when it's done by parties and not done by all these other groups. So I was very pleased to hear you say that you did not think they were corrupting. Thank you, Mr. Chairman.
Very noble.
Just very quickly to try to bring this back to a little bit of focus on the regulation in terms of its attempt to deal with the question of contributions to political parties, not expenditures by political parties, but contributions and the sources of contributions. And I understand that there's a lot of disagreement about whether or not corporations or labor unions have a corrupting influence on the process and whether they should be allowed to contribute. But can we at least agree that Congress intended to limit corporations and labor unions' influence in federal elections?
In federal elections?
In federal elections.
Yes.
And can we agree that the Supreme Court has said that that is a compelling governmental interest, that corporations and labor unions pose the threat of real or apparent corruption in federal elections?
The courts to date have recognized that, yes.
Okay. So then the question comes back to a simple question in my mind. The answer may be difficult. The question is simple, is what does influence federal elections? And the question being, in some contexts, whether it's express advocacy influences federal elections, in other contexts, it may be something broader than that. Can we, I don't know if you were here earlier, but we discussed whether or not there are differences between political parties and other organizations. And there's a tendency in these discussions to start talking about other organizations. Again, here we're talking about political parties. Even going a little bit broader, the Supreme Court in Buckley acknowledged that expenditures of candidates and of political committees so construed can be assumed to fall within the core areas sought to be addressed by Congress. They are by definition campaign related. Can we acknowledge that political parties, and this I think goes to the chairman's question also as to the tax status of political parties are campaign related? They may do other things also, but they are campaign and election related.
They are politically related. In other words, the national committees, both on the Democrat and the Republican side, are exempt under the code as a 527 committee. Clearly, they undertake issue ads, they undertake support of candidates, et cetera, both at the federal and the state level. So they do have a broader definition there than just candidate activity. But with that qualification, I understand the point that you're making. I would acknowledge that they do have a political purpose.
So regardless of what certain states may have decided, whether or not cooperative labor contributions are corrupting the process, we can then at least agree that on the federal level, Congress has decided that corporate and labor contributions, general treasury contributions, can be corrupting the election process, and therefore Congress intended to regulate them. And the real question is how far that goes.
The money coming into to federal candidate committees and political organizations that are federal committees, the courts have acknowledged that that is a corrupting influence. It is something, by the way, that I would take exemption to, as I've noted in the testimony, given that you've got 27 states out there that do permit direct corporate contributions. The money, however, being expended, and I do disagree with you, because I do think you have to take a look at what is that money being expended for. And the courts have taken a look at it, and with the relationship to the political parties, indicated that you're not going to be able to corrupt the candidates. In other words, you can take the money in. It's a question of, and that's not necessarily the corruption. The corruption is the money going out to the political candidates themselves, and is that a corrupting influence? And that, I think, is where we disagree.
No further questions.
Any other questions? Very well. Thank you both, Paul and Ms. Mitchell. We will take a brief break. We're going to try to get back on schedule. We have some witnesses who are expecting to come at 2 o'clock, and I would hope that we can meet them. So we commissioners who blathered on much longer than we should have will have to just have a very quick bite to eat lunch, and we'll see if we can pick up again at 2 o'clock. Thank you.
I've heard work. Yes, sir. I didn't think it got anything. I will tell you.
If we got copies of our statement, wherever people pick up the copies. We know they out on the table. Like, they probably want to get them out.